Muy buenos días con todos.
Good morning, everyone. Welcome to the third regional tribunal for the rights of nature, Amazon free of fossil fuels, a tribunal that is being developed in the city of Puyo in 2026. And it's an honor to welcome especially our Andwa sisters that will carry out an opening ceremony. Thank you for being present here.
Ichakanimia, Ichacuaki, Muchaja, Virginia Dawa. Muy buenos
Good morning. We would like to greet each one of you, brothers and sisters from different peoples and countries that are present here today. My name is Virginia Dawa, and we'll be starting with a ritual and a chant in my language, Andwa.
Ishihimahi andoya, Icha peraka hano, Icha peraka hano. Ishihimahi andoya, Icha peraka hano, Icha peraka hano. Ishihimahi kwahaker, Ishihimahi kwahaker, Ishihimahi andoya. Icha peraka hano, Icha peraka hano. Ishihimahi kwahaker, Ishihimahi kwahaker, Ishihimahi andoya. Icha peraka hano, Icha peraka hano. Hi!
We call on the authorities so that they come to the front so that we can do the ritual.
A los jueces, por favor.
We call the judges, please. Thank you so much to the Andean nationality for the opening ceremony. I think we are all ready to start with this great session today. Welcome everyone to the third regional tribunal of the rights of nature, Amazon free of fossil fuels. For us, it's a pleasure to welcome you here today. My name is Natalia Green. I'm director of the Global Alliance for the Rights of Nature and secretary of the International Tribunal for the Rights of Nature. And today we're going to be discussing a topic that is a concern for all of us. We know and we are aware that science tells us that climate change has reached an extreme limit. And we know what is causing it. It is caused by the burning of fossil fuels and the fact that we continue to exploit such a biodiverse place as the Amazon. It is a concern for us. In spite of all the scientific studies that say that all of the heat waves that are happening in the world, everything that is happening in respect to climate change that is affecting the world, we should actually be going into an era outside of fossil fuels, but an analysis shows that oil companies compete among themselves to extract more oil and gas from the underground. According to TPI, the Global Climate Transition Center of the School of Economics of London, Shell, ExxonMobil, and other 7 companies that are in the market want to increase the production in 14% between 2022, 24, and 2030. This reality is a concern for all of us, and we are concerned because it affects one of the most biodiverse territories in the world. It's one of the most important areas that should be one of the first to be considered as an exclusion area, which is the Amazon region of the 9 countries of the Amazon basin. This tribunal that meets during the 12th FOSPA in Puyo is holding this tribunal so that we can understand that in spite of the recommendations of science to stop using fossil fuels and to move outside of them, they are expanding. We have been able to hear these cases. These were presented in Santa Marta during the Santa Marta conference so that we can move out of fossil fuels. In the conference in Santa Marta, the judges of the tribunal received and accepted the 6 cases that we will be hearing today from Brazil, Colombia, Venezuela, Bolivia, Ecuador, and Peru. Cases that have an impact in all of us present here and those online. These are cases that show that this is a very different reality in the territory, that communities continue to suffer the impact of the expansion of the oil frontier, and this reality we want to make visible with this tribunal. In the tribunal, we will have this wonderful panel of judges that I will be introducing. Our judges, being an international tribunal, a platform that is non-binding but an ethical platform, are judges that have an ethical and moral trajectory that is impeccable. And for us in civil society, we admire them, we honor them, and we respect them as authorities for us. That's why I have the pleasure of presenting to you the president of this tribunal, Patricia Walinga. Patricia. Patricia Walinga from Ecuador, from the Quechua Sarayaco indigenous peoples, is the defender of the rights of nature, of indigenous rights, and she's a former leader of foreign affairs of the Quechua people in Sarayaco, and she's a member of the Permanent Forum for Indigenous Affairs at the UN. Patty, you represent us, we admire you, and thank you for being in this space. Your leadership has contributed to the protection of the living jungle and also the protection of the historical case before the Inter-American Human Rights System and the fight to stop fossil fuels and to have them underground in the Amazon region. Thank you, Patty and Sarayaco. You are representing them. Thank you for being here. Next, I'll be introducing the co-president of this tribunal, Gregorio Mirabal, Jose Gregorio Diaz Mirabal. She is an indigenous leader of the Curipaco leader, born in the community of the Gorinuma in the state of Amazonas in Venezuela. After being a general coordinator of the COICA between 2018 and 2022, he currently coordinates the climate change division of the organization, and he is a speaker for the 8025 initiative. He has represented indigenous peoples in important fora, and he was recognized as one of the most committed persons in climate action. Thank you for being here. Next, I'll be introducing Tatiana Roa from Colombia. Tatiana Roa, thank you for being here, Tatiana. Tatiana Roa Arbedaño is an ecologist, a politician in Colombia. Tatiana has been a minister of the Ministry of the Environment in Colombia. He is a coordinator in Zapagua Viva, and she has worked as a researcher, consultant, and popular educator in topics related to political ecology, climate justice, and social environmental conflicts. Thank you, Tati, for being here with us. Next, we'll be introducing our dear Alberto Costa from Ecuador. Alberto Costa is an economist. He was president of the Constitutional Assembly in 2008 that recognized for the first time the rights of nature in the world. He has published many works where he exposes the extractivism and arguments against mining. He is a former minister of mining and oil. And thank you for being here, Alberto, and for being one of the founders of this tribunal. Next, I'll be presenting Ayubelis Natalia Morales Blanco from Colombia. Ayubelis is a socio-environmental leader born in Puerto Vilche, Santander. She is a municipal council member against fracking, and she has a leadership against the fracking and commitment in the protection of the Magdalena River and the wetlands. She was recognized with the Marianne Initiative in the government of France for the Defenders of Human Rights, and she won the Goldman Prize 2026. Thank you for being here. We also have the presence of Alfredo Wagner de Almeida. Alfredo. Alfredo Wagner de Almeida is an anthropologist and researcher in PhD programs of the Marañón University and Amazonas University. Since 2004, he coordinates the project New Cartography, Social Cartography in the Amazon region and Traditional Peoples, Ethnicity, Agrarian Conflicts, Social Movements, and Territorialization Processes and Social and Political Cartography in the Amazon region, specifically in the defense of the Quilombola people. He has participated as an expert witness in the Permanent Tribunal of the Peoples and before the Inter-American Human Rights Court. Thank you, Alfredo, for being here. And finally, we would like to present our dear Mariluz Canachini. Mariluz. Mariluz, she's a wonderful Cucama woman, leader of the Cucama people. She has been a leader for the recognition of the rights of the Marañón River. This recognition and leadership and struggle has led Mariluz to be one of the winners of the Goldman 2025 prize and an important leader before the first case of the human rights case and rights of nature case in Peru. Thank you for being here, Mariluz. We also have present here our dear friend Francesco Martone. Francesco is the director and president of the Assembly of Judges of our tribunal. Our assembly has more than 60 judges. He is an Ecuadorian Italian leader that has worked a lot in indigenous people topics, and he's now leading the important assembly of the International Tribunal for the Rights of Nature. Thank you, Francesco, for being with us. And we also have with us 3 prosecutors, mainly Mario Melo, who will be occupying 5 of the 6 cases. And I will give the floor to Mario, if you can stand up. Mario. An applause for Mario. Mario Melo Ceballos is an attorney and an Ecuadorian academic. For 25 years, he has been defending the rights of nature. He has been a lawyer of the Sarayaku, Tagari, Tananane people and other victims in victorious cases before the Inter-American Human Rights Court. He has been an attorney for other peoples and in rights of nature cases. As an academic, he has been dean of the Catholic University of Ecuador, and he's a professor of the Center for Human Rights and the Rights of Nature in the same university. Thank you, Mario, for being present here. And thank you, Mario, for having an excellent support team that is assisting you in this tribunal. And in the Foz do Amazonas in Brazil case, we'll have two prosecutors. We'll have two prosecutors. I don't know if they are here. They will be coming later because they are in the House of the Rights of Nature. Dr. Ramiro Avila Santamaria. Ramiro is an attorney, jurisprudence doctor from the Catholic University in Ecuador, and also a professor in Universidad Andina Simón Bolívar, and an expert in, and a member of the, former member of the Constitutional Court. An applause for him. And we also have Fatima Monasterio. Fatima Monasterio is an attorney and activist in Bolivia, specialized in the rights of indigenous peoples and the rights of nature. She has experience in supporting social organizations and communities for the protection of territories aimed at the protection of life. She works with the Salom Foundation. Thank you, Fatima, for being with us here today. Both Ramiro and Fatima will be judges of this case because they will supporting the case in the territory. The other cases will have will be presided by the Earth prosecutor Mario Melo. So they are not judges; they are prosecutors. We'll like to give the floor to Carlos Marcel Espinosa, director of the House of Culture in Pastaza, and thank you, Carlos, for welcoming us in your house. Thank you.
Un saludo muy
Cordial greetings, cultural greetings to everyone.
buenos días.
Good morning.
Alipunja, buongiorno. Good morning. Bon dia.
Especially our greetings to the people who honor us in this tribunal, these excellent people at the Pan American and world level, to all people present, and for the reason of being of this third regional tribunal and the 12th Pan American Forum, FOSPA. Welcome to the Ecuadorian Amazon region. Welcome to Pastaza, the most extensive province in the Ecuadorian territory, with which is a place where we find 7 nationalities of the 14 nationalities that we have in Ecuador. Welcome to Puyo, the Canela city, the door to the Amazon region. Welcome to this, your house, your home, the House of Culture, where we disseminate creative art and we promote culture at the regional and national and international levels. I had prepared a brief text, but I think that this is a timely moment to say what I can express, to have these the honor of holding such an important event. Allow me to say that we are honored to raise awareness in this international forum, raise awareness on the analysis of non-extractivism of black gold, and also to raise awareness to the fact that today they not only want to extract oil, but also they want to carry out illegal mining. And this is killing us. How far they can go, really, with the greed and ambition of power and materialism in Ecuador and the planet. We are truly afraid, and that's why I'm happy that we can hold this event here. Imagine that illegal mining is actually reaching the Yasuni, and you know what the Yasuni means to us, the natural reserve we have there. So this is going to be a moment where in history of human beings, you will see that oil will be depleted. Maybe in 20, 40 years, oil will be depleted in Ecuador, and what will we have to live from? Let's not think about that only. Let's think about the future of our children. And living cultures are being exterminated as well. So thank you for bringing this forum here to raise awareness and in the Ecuadorian and the Americas and the planet. I don't want to say more. I just want to wish you a productive session for the benefit of humanity, because the Amazon is the lungs of the world. And let's hope that thanks to Pachamama, we'll have a biodiverse Amazon region, an exotic region that we have. Thank you, everyone, and may you have a very fruitful session. Thank you.
Thank you very much for that welcome, and thank you to the House of Casa La Cultura for welcoming us here. Before going to Francesco, I want to thank the team that has made this possible. I want to thank Maria Vanerus. Maria is the organizer of the tribunal, and I want to thank her for her arduous work, because without her we wouldn't be here. So thank you, Marie, for all of this, for all the team from GARN and all the people who have made this possible. Thank you to communication, everyone, the interpreters. We're going to have a very important day too. So thank you very much, and a round of applause for all the team that made this together, made this possible. Next, we're going to give the floor to Francesco Martone, the president of the judges of the tribunal. First, I want to begin my opening by expressing indignation in condemning the killing of an indigenous Venezuelan leader, Julio Rodriguez, leader of the Juvi Econai people, assassinated because of his commitment in the resistance against mining. Julio is only the latest in an unacceptable list of murders of leaders, indigenous leaders, guilty only of defending their land against the advance of extractive industry and for the assertion of the rights of indigenous peoples. This tribunal is at their side. And the importance of the role of the defenders is very important for us, just as it is to bring our work to the territories, to the places of fight and resistance for the free determination of indigenous peoples here and throughout the Amazon. It is not a coincidence that we had as guests in Belém Michel Forst, the special spokesperson of the NU, of the UN, and the special spokesperson about the rights of human rights of the UN. And I thank the company of Pedro Argollo, who is the spokesperson UN for the rights of water. So for us, an important acknowledgement of the role of this tribunal is in the progress of fundamental rights. I was in Puyo 22 years ago. Back then, I was a senator of the Italian Republic, and I was invited by the OPIP to see the effects of the extractive industry, especially AGIP in Campo Villano, and I was able to contact the communities of resistance and to see what is the real impact of the international corporations in this region. And from then on to today, we are here celebrating the resistance of the Amazon peoples that are an example to the world in the defense of territories and the fundamental rights against extractivism, and for alternatives based on indigenous cosmologies and ancestral knowledge and indigenous wisdom. We will hear the cases of different countries where this tribunal is going to have a ruling regarding the uh, infringements of the human rights, the rights of nature, and the rights of indigenous peoples. We're going to have judgment that will have take into account these claims on these cases, and is also going to propose reparation measures in case of infringements or preventions in the case of risk of infringements. These are cases that go beyond the information that is going to be shared today by our colleagues who are working next to us. These are cases that are embody resistance, day-to-day struggles, pain, and seeing nature and communities that are threatened by the advance of the extractive industry. And for us, this strengthens even more the responsibility that we have as a tribunal to offer spaces of denouncing, of having truth and justice. And having this tribunal here today in Puyo, in the heart of the resistance to oil companies, but also during FOSPA, has a particular political sense. We cannot forget the importance, for example, at a world level, of the campaign to have keep oil underground in Yasuni, but also to anchor the resolutions of this tribunal within the framework of the defense of the Amazon as a subject of rights and have lands free of fossil fuels. Here, territories have been liberated by part of sovereign decisions. Just 2 minutes, sorry. 2 minutes. Sovereign decisions of the indigenous peoples, and we accepted this mandate that comes from the territories that also inspire the political sense of our action. And these are decisions of these tribunals that are not substituted, do not substitute the sovereign decision of indigenous peoples, but gather and amplify and offer tools of incidence at an international level and the Create Alliance of Convergences. We recognize also the importance of indigenous law and indigenous wisdom in informing our decisions and bringing down the rulings or judgments to the territories. We receive claims from the territories. We analyze them and we offer to the territories this judgment as an instrument to strengthening the resistance. So it is a circuit of receiving and restituting fundamentally. The problem that we're going to see after this judgment, what will happen? This judgment will be given to governments, to companies, to international organizations, to the Inter-American Human Rights Court, and to other international institutions so that we can accompany you who are appealing to this tribunal in the process of follow-up to fulfill this judgment. If the states or the companies will not do it, we will do it from down up to strengthen the initiatives for an Amazon that is free of fossil fuels and is subject to rights. Thank you very much and good work to all of you. Thank you very much, Francesco. And as the cases progress, we will tell you also that we already invited the responsible parts of the cases, and we have had some responses from the cases, and we're going to tell you this on the way. To continue, we're going to call Pablo Solon because we are doing this forum during this tribunal, during the Amazon, during FOSPA, and we want to see the link, especially with House 1, the House of Territories Free of Extractivism, and we're going to hear about what has happened from Santa Marta to the present and what is happening during FOSPA and how this is linked to the tribunal as well. Go ahead. Good morning. Receive a brotherly greeting to all the judges, to the secretary of the tribunal, to the prosecutor, and to all of you. This FOSPA is very particular. It's very different to the previous ones because the Amazon lives a new period of neocolonization that we hadn't seen in many decades. We have in the Amazon ultra-right governments, neo-fascists, who are destructuring, aim to destructure and destroy everything that has been achieved regarding environmental and indigenous rights. Brazil is an exception, but although it's an exception, we have to say it. Lula's government has also made flexible indigenous and environmental regulations in the last few years. What does this mean? How must we change our strategies with this new situation? This is the issue of discussion in the forum, in particular with regarding the rights of nature. Obviously, we have to continue having advocacy in these governments, but it's going to be more and more difficult because these are extreme right governments. Towards international organizations, we have bodies, we have to continue doing it, but these are ever more weakened and fragmented. Regarding justice institutions, obviously, but we're seeing more and more that justice is more and more co-opted by the states. In conclusion, where do we have to put the emphasis of our actions? In our territories, in our municipalities. The important thing, the central thing here is what do we do in our territory to guarantee the rights of nature without waiting too much for the state or justice or international institutions to do something. The important thing is to discuss what are we doing here in Puyo so that Puyo can put out an ordinance, say, to guarantee the rights of nature in Puyo so that the same thing can happen in Rurrenabaque municipality, in the Moseteng indigenous territory. What mechanisms of self-regulation can we provide? And how should these happen? How do we make rights of nature from down up? This is the new time, the new challenge that we have. And this implies that contention measures from the territory, from the municipalities to stop mining, to stop the exploitation of fossil fuels, to stop the agrochemicals and agrotoxics, to stop the explosion of carbon bonds that are throughout our territories in the Amazon. So I think that the challenge of this tribunal, besides listening and making a ruling or judgment on these cases, is how does this tribunal guide the movement of the rights of nature in this new time, in this new moment of new neocolonization that we are seeing, neocolonizing, and how do we move from having more to more concrete actions, more territorial, more specific measures of what we have to do from down up, from our community, from our territory, from our municipality, to start creating the reality of the rights of nature beyond what these governments and this corrupt justice will do. Thank you very much. Thank you very much, Pablo, and we wish the best for the result that we will present tomorrow in FOSPA, which we have been working since in House 1 for a long time, since Santa Marta, for a territory that is free of extractivism of oil and mining, and for an Amazon with rights. Next, we have the honor and pleasure to be able to present the rapporteur from the United Nations about human rights, water and sanitation, Pedro Roque Argudo. Thank you very much for accompanying us here. Go ahead, Pedro. Well, first of all, I am really amazed and very honored because we are here for so long. He said we have to go to FOSPA, right? To present the work that we do, as like I explained yesterday. So thank you very much. I have come here, really, I'll say it, to learn. And I am going to listen. mostly. Maybe in just these few minutes, I'm going to offer something that I am suggesting very humbly as a reflection that people who are moving forward in the aspects of the law and the rights of nature, I would like to suggest that if what I am going to propose is useful and what I think that is very important, this work that you are all doing. One of my thematic reports, each year we have two, in front of the General Assembly of the United Nations and the Plenary of Human Rights, was centered in an idea that I've been insisting upon a lot regarding the rights, human rights to drinking water and sanitation, is the challenge of making peace with nature if we want to move forward in the effective development of human rights to drinking water and sanitation, particularly for the peoples that are in the most vulnerable situations. Having available nature in good state cannot be a luxury for rich people. It is a need for survival and for existence of those who live more directly in relationship with nature, which are usually also those who are most vulnerable. And I think that simply the idea that I want to suggest is that in this report that I created, that I drafted on this subject, I suggested the following. Obviously, the lessons that are being taught, the drive that is provided by the indigenous peoples from their ancestral knowledge of recognizing the rights of nature and in particularly of the rivers and aquatic systems comes from a ecocentric vision, a vision where humans are not the dominator, but they're part of the privilege of life that we share. This is the most consistent thing. However, we live in a society where, let's say, the global north, the culture, the dominant culture of supposed progress, has a vision that is anthropocentric, based in this madness that we imposed on the world of the paradigm of domination of nature. But remember that this paradigm is obviously in crisis, and it's in crisis by its results because we are very quickly moving towards self-destruction, and not only towards indigenous peoples in certain sectors, but for all of humanity. I think that this is a reality that has led us so that in this moment we cannot talk in peace about the paradigm of domination of nature, and we need to talk about the emergence of a new paradigm of sustainability. So it's not bad. Sure, it's a paradigm of sustainability from an anthropocentric view, from what it brings to us, not with the consistency of this ecocentric vision of wise humility that implies that vision. But if we're not going to say it's because of how it serves us, from my point of view, then welcome at least that. This approach that has to open its trail, blaze its trail against the current. But this is within something that nobody would like to argue. I would suggest two more elements in this line, along this line. The United Nations, after important efforts, and just recently recognized the human right to a healthy environment, to in good state and sustainable. Well, again, because of the benefits that it brings to humans, fine, but welcome still, because what it means is that the objective or the obligation of a human right to safeguard the good state of nature above all other interests and other goals. And one final concept that is starting to appear in the United Nations is the English concept of One Health, which is being employed systematically, at least in its discourse, throughout the WHO, FAO. Well, they say there cannot be human health, public health, if we are not considering the ecosystem health, where the whole of a territory of the ecosystems that provide us health are healthy. So these approaches are anthropocentric, Agreed. Yes. But from my point of view, if without explicitly recognizing a self critic from the global north, what we are doing is converging some way, somehow, with the consistency of the approach of the rights of nature that we are defending here. So I suggest that from the aspect of person working in law and the law, I don't feel capable of doing it, but to articulate properly how to strengthen this coexistence approach of the rights of nature, how we can strengthen it by pushing also from this convergence of this approach that although it's anthropocentric is in the end a self-criticism, at least because of its benefits they bring us, of nature that nature brings us. Thank you very much. Thank you very much to this special rapporteur for accompanying us in this important space. And now I am going to give the floor to Patricia Walinga, President of the Tribunal, and so that she can inaugurate the Tribunal.
Buenos días.
Good morning.
Gracias por estar aquí.
Thank you for being here. To all of you in the Third Regional Tribunal of the Rights of Nature, with an approach that is very special and very important, an Amazon that is free of fossil fuels. Receiving here in the capital of Puyo, the capital of Pastaza, the cradle of the 7 Amazon nations that have different cultures, languages, and territories, it is an honor that FOSPA is taking place here and the tribunal as well, because this province fights so that there isn't a broadening of the oil frontier. Here in this process, we have had flagship cases of resistance. Here we had the proposal of the living jungle appear. So it's very symbolic that all of this is taking place here in Puyo. It is not a coincidence because at some point they say that there are no coincidences, and I think that these are being articulated in this unity that is happening in this province. And in this tribunal, we're going to listen to painful cases of the infringement of rights, cases that really affect people and affect us. We know all that we're in a point of no return and how important it is in this context to have an ecosystem, the Amazon ecosystem and biome. We cannot fail in this fight, in this defense. We have to be together. And this is a profound meaning that we have in this territory. Why do we talk about Amazon that is free of fossil fuels and oil? I would go beyond this, free of all kinds of extractivism, because it's necessary. Why is it necessary in this critical juncture, even for humanity? And despite the fact that we say that nature has its own rights, this right is so intrinsically linked to the rights of each human being, to the right to live healthy, to survive, and to exist. Because without nature, we are not going to be able to exist. And this is a concrete, real fact. Without these ecosystems, we are not going to exist. And I not refer only to the indigenous peoples, but to the whole of humanity. And this meaning is so broad that if we are able to have these spaces be declared completely fossil fuel free, we will have done a great humane labor. So I am inspired, my fellow judges. I am inspired by the great presence of indigenous peoples and nations that are in these spaces seeking for this profound transformation that is so needed by humanity. We are going to play the role of listening very clearly, but also very intuitively and with greater
todos
sensibility,
los casos, para que podamos dar la fuerza
sensitivity,
de esa
so
fuerza
that we
que
can have
necesita.
give force
Todos
to
los del tribunal somos jueces
visibilization.
éticos.
We
Y
are
sí, y sí,
all in the
esa
tribunals.
ética
We
nos
are
da la
ethical
fuerza
judges
de
that
seguir
will, and this
inspirándonos
gives us the
en los
strength to
casos,
continue
pero
to be
también
inspired
seguir
by the cases, but
apoyando
also to
desde
continue
esos espacios
supporting
de los que
from the
tanto
spaces
hablamos.
that we,
Estoy
from the
compartiendo
roles we play.
la
I am sharing the
presidencia con
presidency here
Gregorio
with
Díaz
Gregorio
Mirabal,
Diaz
que es
Mirabal, who
también
is
el otro
also the other
presidente que va a hacer
president
el
that is going to
cierre
do the
de
closing.
todo
But
lo
I
que
have
vamos a
had the
hacer.
honor of opening
Con estas
this. So
palabras
with these
doy
words,
la apertura
I
al tercer
inaugurate the
tribunal
third
regional de
regional
los derechos de
tribunal
la
of the
niña.
rights of nature.
Muchísimas gracias, Pat.
Thank you very much, Patti, for inaugurating this important tribunal that will listen to 6 cases that are extremely important. And so next we are going to our prosecutor of the earth, Mario Melo, who is going to uh, open proceedings and call witnesses. Good morning. Earth claims for justice, and she does it through the beings that have the constitute the community of life. And in this tribunal, we're going to introduce representatives of traditional peoples that live in the jungle, that live in the mountains, that live along the sea, and they are going to be presented so that we can. They will claim, they will cry out so that they stop the aggressions of their vital spaces and their cultures on the aggressions that come from the oil industry. I am honored to represent the earth in this audience as its prosecutor and have the opportunity to call the plaintiffs in 5 cases in which this tribunal will have the opportunity to hear testimonies that are key to understand the reality that is being lived in the Amazon region. Judges of the International Tribunal for the Rights of Nature, the prosecutor of the earth wants to present its first case. The case refers to the broadening of the oil frontiers in Ecuadorian Amazon. The Ecuadorian government has announced once again that it is going to start new oil explorations that were going to affect the center and south of the Amazon. This is a pristine region where Amazon forests in excellent state of preservation are the home of 7 indigenous nationalities and of an infinity of beings, physical and non-physical, that depend on the harmony of nature for its survival. The new rounds of oil exploitation put at a very imminent and grave risk the disturbance of this community of life. I'm going to request call on the first witness for the prosecutor. I request from the tribunal that they receive a testimony of Mr. Franklin Mayacho.
Con su venia voy a proceder a hacer el interrogatorio.
So, with your permission, I will proceed with my interrogation. Mr. Franklin Mayancha, why are you an ideal witness to declare in front of this tribunal? Mr. Judge, good morning, Mr. Members of the tribunal. My name is Franklin Mayancha, president of the Zapara Nation. I have been a legitimate member born in the territory of the Zapara Nation. We have 23 communities, and I am their representatives. I state that I represent these nations. Mr. Franklin Mayancha, how does the increase of oil activities in the center south of Ecuador is going to go against Mother Nature? Mr. Judge, this would accept this would have an impact on the forest and the water. It would affect animals. It would affect the soil and the climate. It would affect health. Not only that, not only the oil, but it would also cause the death of our animals, of our medicine, and of our rivers. Mr. Mayancha, please explain to the tribunal how these impacts that could be caused by the oil industry are going to affect the forest and the beings that live in the forest. Well, from what we have talked about the four impacts, we can have affectation because of pollution. We can have affectation problems in our culture, and the land could end up being destroyed. There can be illnesses in our families in the Amazon. Could you explain to the tribunal, please, how oil activity could damage water? Water could be polluted, and so could the inhabitants of the population, our young children, our young people. They could fall ill and could die. Thank you very much. Thank you very much.
I request the testimony of Mr. Daniel Tawa. Mr. Dawa, why are you an ideal witness to provide testimony before this tribunal? My name is Daniel Dawa, president of the Andua nationality in Pastaza in Ecuador. I come from a community, the Pucayacu community in the Montalvo parish. Mr. Dawa, how will oil projects will affect indigenous communities in the center-south of the Amazon? I come from a territory where I have observed directly the great impact of our territory and on our nationality in Peru. I have seen the reality where they have been affected, our Pachamama, our Mother Earth, where we have walked with our children, with our young people, and also with our leaders in each of our communities. And the Ando nationality in Peru have lived 50 years of oil exploitation. And what's the relationship of the Ando communities with the territory? Our relation is a direct relationship. We as indigenous people, we coexist with Mother Earth, with our waterfalls, with our rivers, and with our lakes. That's where we find our education, our wisdom and teachings, and our way of living. And what could be the danger of posed to this relationship if the oil industry enters this territory? Mother Earth and human beings cry when we are affected, when we are hit. Our blood goes out, and also our trees cry. And that's why we declare today in the Amazon region that we don't want to be affected by oil. Mother Earth also cries, the anaconda, the tiger also cries, and that's why we are here present. What are the activities that the Andua people carry out to cover their daily needs in your territory? According to our worldview, we have strengthened ancestral knowledge and wisdom. We have the icon of Andua women and men are present here. The Anda women live with the anaconda in their farms. The anaconda men live with the Atzari because the tiger is the one that defends our habitat and home. That's how we live in the Ando territory. And that way of life, is it possible to have it if the oil activity goes in your territory? This will affect the Andua people, and we will eliminate and erase our language and identity and way of life. Thank you so much. Thank you.
Con la veña de
I request the tribunal to receive the testimony of Mr. Luis Galenos.
señor Luis.
Mr. Luis Canelos, can you please explain why you are an ideal witness to declare and provide testimony to this hearing? Judges and public present here, thank you, prosecutor. Indeed, I am the son of a historical people in the Amazon region in Ecuador, Canelos, more than 400 years of community existence. A son that today I am leading the Quechua people that gathers more than 200 communities in a 1 million hectares, and I know the reality of the territory. I have walked our territory, and we know the conditions where we live in our territory. Therefore, I think I am an ideal witness to be able to defend our territory. Mr. Luis Canelos, can you please explain to the tribunal what's the relationship you have with between the Quechua communities and with the spiritual dimension? We, as Quechua people in Pastaza, first of all, we have declared our territory as a causa xachai, that is, a living territory, the living jungle. Living beings with a conscience and subjects of rights where we coexist. Our relationship with these vital spaces is a direct relationship with the spiritual beings. The communication we have is directed through the different cultural elements that we have in our territories, medicinal plants, our wise people that connect to nature, the rivers, the waterfalls, the Sachakruna with the spirits that live in the jungle. Can you please expand to the tribunal the concept of causa xachai? What does it mean to me to be causa xachai? Causa xachai is a living territory in space where all beings, from the smallest ones to from the most spiritual ones, and we coexist within this vital space. This is our living space, a life space. We need the Kausak Sachai to reach a Sumakausha Sachai, which is good living, which is recognized in our constitution. So all of them are spiritual beings. Water, the Kaipacha, is the time and space as being, and all of those beings that live in the underground for this. And so this is our living space. In the Quechua worldview, Kausak Sachai, does it have a conscious awareness? Yes, all living beings have a conscience and awareness, and that's why consciousness. And That's why we talk about a subject of rights. And so this consciousness allows the Kausaksacha to feel pain when they are harmed by activities such as the placement of explosives or the extraction of oil. Indeed, when our territory is sacrificed, when they use explosives, they feel pain. Mother Nature is like stabbing our hearts, and that's what our soil feels. Our Kausaksacha feels a wound that cannot be healed over time. And if the jungle receives this stab, if the jungle is stabbed, can it be the same mother that it has been until now for Amazonian people? Well, yes, it is our mother. It is what gives us life, and we depend on the Kausaksacha for our existence. How will this affect? How will oil activity affect this mother relationship you have with the jungle? Well, the oil exploitation that we are facing with this sub-Indian round. The sub-Indian round is located on the mountain range where we have our water sources, and they want to exploit resources there, and this affects the basins that are downstream in our communities, and we depend on rivers and the spirits that we find there, the abundance we have there, fishing and food security we find there, everything that has to do with these vital spaces that we have in the Kausaksacha. Thank you so much.
Con la venia del
I request the tribunal to receive the testimony of Alex Aldana.
Por favor, señor Aldana, explíquele al tribunal.
Please, Mr. Aldana, explain to the tribunal why you are an ideal witness to provide testimony. Good morning, members of the tribunal. Jerry, we are facing an emblematic case for the province of Pastaza in the South Center. I am the son of the grandfathers and grandmothers that traveled through the Nasa River, and also a grandson of the Copatasa River, and as a lawyer and as a defender of the territory, I'm here to defend what concerns us as children and members of this nationality in the Pastaza municipality. Mr. Aldana, can you please explain to the tribunal what risks are posed by oil activity for the defenders of nature and indigenous peoples of the Amazon in Ecuador? The members of the tribunal, although in the municipality and the province, Puyo and Napo and Pastaza, we have always defended our territory. Yes, the nationalities in Pastaza are the cradle where we find our habitat. And we, as peoples and nationalities, we have the capacity to defend our territories because this will affect what we are living now, what you have seen now, in terms of those who inhabit the Pastaza region. This will affect the autonomy and governance that each of the communities have had in terms of exercising these rights. This will affect our autonomy, as I said, and we do enjoy having assemblies for decision making and organization of decisions, and this will affect us in terms of territorial conflicts between nationalities. What has been the experience of the Ashuar nationality in terms of its relationship with oil activity? The Ashuar nationality in our territory, we don't have an extractive company. More than 98% of our territories has been conserved. We have had complications at some point with Block 10, Block 24, and we were part of the commitment and struggle supporting our indigenous brothers in the Sarayaco community. We also participated in the defense of the territory with Block 24. We defended the territory. And thus we have a living relationship as a Shuar nationality. We have defended the territory because it's our home. I ask you in this hearing, jury, would you allow someone to come and to break your door and take your children? Will you allow that? I think not. So we as members and members of the community and defenders of our home, this is our habitat, and in the Amazon region, nature has rights that we have lived on a daily basis, and we enjoy them. So, dear members of the jury, as indigenous nationality of the Amazon region, we defend our home. Before we move on, I ask the tribunal if they have a question to the witness, for the witness. Mr. Aldana, please, I would like for you to explain how are you defending the territory based on the Ecuadorian Constitution? Well, it is true that in Ecuador we have emblematic cases with judgments in favor of the nationalities such as Sarayaco and Cunacoe, and one ratified by the Constitutional Court with the Waurani people. This ratifies that they have violated the rights of peoples and nationalities based on the prior and informed consultations because they didn't do a due consultation. So, in this sense, members of the jury, as defenders of the rights of nature and as an attorney, we are preparing the legal strategy because there is a precedent with emblematic cases where we now, as Ecuador, we have seen on a daily basis in our defense of the territory, and you can now see it yourselves in the region of Pastaza. We don't have an extractive industry at the moment. To complete the information, if you allow me, President of the jury, can you please inform us about the free, prior, and informed consultation that was not conducted here in the province of Pastaza? I think it was in Block 22 of the Waurani community. And I think this is very important, Madam President and colleagues and of the jury, considering that in Ecuador we have constitutionally established the free, prior, and informed consultation for indigenous peoples and communities, Article 57, paragraph 7, that has not been complied with. But you here have a very important case, which is Block 22. Yes, Mr. Judge, a member of the tribunal. In the year 2012, they conducted the due consultation supposedly to several nationalities in Pastaza. At first, they had a favorable ruling by the Ministry of the Environment, but looking at the case of the Guarani people, today the Constitutional Court ratified that indeed there was no prior free and informed consultation, because you need to understand that the consultation must take place in the ancestral language of each nationality. So in this sense, we have an important precedent in Ecuador that was ratified that there was a violation of this right to the right of free and informed consultation. Thank you. I would like to hear the opinion of the witness, Natalia Yepes, that also knows about this case. I think that it's very important, the president of the jury, to know about the implications of this trial that in 2012, took place in 2012 with a judge that was actually a misogynist. Even we learned about that. I think we need to take into consideration the Constitution of Ecuador that was passed by the Ecuadorian people in 2008 and ratified in 2025. In this Constitution, we, for the first time, approved the rights of nature, the nature as a subject of rights. And we have a series of provisions such as Article 57. The free, prior, and informed consultation was passed for indigenous peoples and nationalities, and also the environmental consultation for the rest of society, Article 398. I would like for lawyer Natalia Yepes to inform us if there was a prior pre-legislative consultation that should have been conducted. And if you allow me, President of the jury, I can share with you the Constitution, because for Ecuadorian people, this is a reference to be able to build a country based on social justice, ecological justice, through direct participation, that is, through radical democracy. Allow me to share with you and distribute the Constitution of Ecuador. Good morning, President of the Tribunal, judges, the Earth prosecutor and the secretary, and of course the key witnesses of the defense of Mother Earth and everyone present here. For the purpose of the hearing, and my name is Natalie Yepes. I'm a lawyer and a human rights defender of an organization that is called Mason Watch, that supports peoples and nationalities in the defense of rights, and it has to do with the defense of Mother Earth. And in this sense, I request that the tribunal and the auditorium to be able to respond to the question of Judge Acosta that can be a key element to understand the case presented by the prosecutor Mario Melo regarding the possible expansion of the oil frontier. Indeed, as you have mentioned, Mr. Judge, Ecuador is a signatory of ILO 169 Convention, and we also recognize among constitutional rights the prior consultation in two dimensions: the free, prior, and informed consultation before adopting extractive plans and programs in indigenous territories, but also the pre-legislative consultation in relation to consultation rights. That is, if something is going to be regulated that affects peoples and nationalities, must be consulted to peoples and nationalities. We have no records in our research that there was a proper process conducted. On the contrary, there were several constitutional rulings and international rulings that determined that systematically the Ecuadorian government has violated this right, and one of them has to do with oil expansion and exploitation. In the concrete case that you referred to, which is relevant to this tribunal, we have the Sarayaku versus Ecuador case with the Inter-American Human Rights Court, where they established that one of the more than 5 attempts for oil tenders or rounds in Ecuador were not complied with, and the Inter-American courts referred the Ecuadorian state to regulate with a high international and inter-American standards to have it as free, prior, and informed. But unfortunately, this case has not been complied with, and the Sarayaco community, which is located in the Quichua Paquiro areas, as we heard from the witness, they mentioned that they have been for 14 years that they have not complied with the measure of guaranteeing this type of consultation. And recently, the Constitutional Court of Ecuador also pointed out that when they tried to sell the 22 block, which is found in the new attempts of the government of Novoa to expand the oil frontier, they also avoided the free and prior and informed consultation. To conclude, Mr. Judges, members of the jury, As the prosecutor stated, this is an imminent threat because more than 5 occasions the 7 nationalities have rejected the expansion of the oil frontier. Unfortunately, they want to reuse the argument stating that there is no violation of the right to free, prior, and informed consultation, and therefore they want to continue with these new 11 oil blocks that will affect 3 million of actors, Mr. Members of the jury, and prosecutor. One thing that I want to clarify, Ms. Yepes, is if you can explain to the members of the jury and the auditorium how this so-called consultation took place in the year 2012, and then the sentence of the tribunal here in Pastas in 2019, and what is the procedure that is being followed by the Constitutional Court, where I find that they would like to set up jurisprudence based on this judgment to highlight the significance of these processes as a reference point for the defense of the territory here in the province of Pastaza, not only in the province of Pastaza, but also in the south center of the Amazon region that has not yet suffered the impact of oil activities that took place in the east of the Amazon region in Ecuador. Yes, Mr. Judge, this is a very important case. For the Ecuadorian case, the jurisprudence of the Constitutional Court is a binding case. We need to understand what happened in the year 2012. In the year 2012, the Ecuadorian government established socialization practices, they called it, about the benefits of the expansion of the oil frontier. This created fragmentation and also division in the social fabric of communities. What they signed is what they called investment agreements, through which they committed certain leaderships with cooptation practices so that they could allow the entrance of initial exploration activities in oil blocks in exchange for delivering certain economic incentives. We even reported at the time the negotiation of social and economic and cultural rights were negotiated. This doesn't comply with the parameters of free and prior and informed consultations. First, because this should have taken place before planning the bids. And this was not informed because the only thing that we have in our research as evidence, and we'll be presenting this to the tribunal, had to do with the supposed benefits that they will receive, and not according to international standards regarding the social and impacts of the oil industry. And it was not public because they didn't respect the organic decision-making structures. That's why I think it is important to hear the voice of these witnesses. They are the legitimate representatives elected by assemblies in their communities. This is what the Constitutional Court determined in the Waurani case, and we hope you can study this practice that is affecting 7 nationalities, 3 million hectares in the province of Pastaza. Thank you. I think that we have enough material. President, Prosecutor, I thank you for the presentation of the witnesses, Mr. Yepes and Mr. Aldana. I think we have, as a jury, sufficient material to make a decision in this regard. Thank you. Thank you, members of the jury. I now have to close the presentation of this case. The Earth prosecutor has brought the leaders of the Zapara, Andua, and Quichua nationalities from Pastaza and a representative and lawyer from the Ashuar nationality. We have also heard the testimony of the defender, and this is a unanimous testimony on the threats to the territories, to nature, and those related to the announcement about new oil rounds. This is not a recent threat. It's close to 2 decades through which the territories have been permanently under surveillance by different announcements of oil rounds. In the struggle of the peoples of the south center of the Amazon region, there are some milestones that are impressive. Perhaps the most important one to date is the one from the Quichua people of Sarayaku that brought their struggle to the Inter-American Court, establishing a ruling that establishes standards at the continental level with the right to a free and prior and informed consultation. Given these iconic struggles, it is necessary for this tribunal to pronounce and state a powerful insistence to the Ecuadorian state that they cannot use indigenous territories without obtaining the consent of the people who are going to be affected. And second of all, if they don't show that the activity that they will be carrying out won't violate the rights of Mother Earth. So the prosecutor believes that there is an imminent and serious threat to the rights of nature and of indigenous peoples of the South Center, and we request the tribunal to take on the responsibility of offering protective measures in favor of the 7 nationalities that would be affected by these oil rounds, and also in favor of Saichai in the nationalities that would be affected by these activities. Thank you.
Muchísimas gracias al doctor Mario Melo.
Thank you very much to Dr. Mario Melo. And next, we're going to hear the Peruvian case. We ask our Earth prosecutor to begin interrogating the witnesses of the Peru case. The Earth's prosecution presents the case of Block 64 in Peru's Amazon region. This is a case in which the indigenous communities, Chapra, Achuar, of our sister Amazon of Peru have been also affected for decades by this block. There's an announcement on the part of the Peruvian government to reactivate this block, with which once again the rights of Mother Jungle and the rights of communities are gravely threatened. With the approval of the tribunal, I request the presence of Mr. Elmer Kunzing. Mr. Kunzing, please explain to the tribunal why you are an ideal witness to declare in this audience, in this hearing. Good morning, honorable tribunal, prosecutor, judges, and auditory. My name is Elmer Kunchim, president of the Federation of the Achuar Nationality of Peru. I must present as a witness of cases that happen in our territory, where we group 66 communities, 6 organizations, and we are located in the district of Andoas Morona, in the province of Aten Marañón, in Loreto, Peru. Mr. Elmer Kunzing, please explain to the tribunal what are the affectations that the oil exploitation in Block 64 have provoked in the jungle in Mother Nature. In our territory, there are several oil blocks, but Block 64 is 60% into our ancestral territory, where in the year 2005, we had the first well. After, they broadened in the year 2009. the second drilling of oil wells where they affected our territory. Then in 2014, the company left after so many struggles that we posed. So in drilling the oil wells, they used several chemicals. So these chemicals remained, and after in a bag, this was buried in the land, and then this bag broke or deteriorated, and our animals drink this, and we consume these animals. And then in the river, our population, our community, drink the water from the river, which is contaminated. And now there are also cases in the lot, in the pipeline of Peru in kilometer 12, in Pastaza in the river 2024. There were damages or affectations to 8 communities. Our rivers, our lakes, our plants, our crops that we consume. So the 3 nations, Achuar, Wampis, Chapra, we rejected the reactivation of the oil blocks because they affect our health, our nature. Also, in our territory, it's not only our work to protect them, but it is our sacred duty that we have to take care of this so that we can live healthily. Could you go into detail about what the territory means for the Achuar population of Peru? For us, the territory, the land is sacred. It is our home. It is our Mother Earth, where it is our market, it is our pharmacy. So we have to take care of it, maintain it, our land, the rights of nature and the rights of humanity. Was the Achuar people ever consulted, or did they give their consent to have oil activities in their territory or in their land? The these oil activities have not been consulted. That is why we rejected this Block 64 and these activities. That's why we don't want oil activities in our Amazon, in our territory. Thank you very much.
Solicito la comparecencia del señor.
I ask the presence of Mr. Elio XII.
Buenos días, señor Helio. Por favor, explique.
Good morning, Mr. Elio. Please explain to the tribunal why you are an ideal witness to declare in this hearing. Good morning, Mr. Tribunal, members of the tribunal, prosecutor, and audience present. My name is Elio Cecen Mariano. I represent the autonomous government of the Wampis Nation, and I must be considered as a witness because I live in the territory and I also fulfill the mandate of my nation. Also, I must inform that the Wampis Nation exists before the Ecuadorian state and the Ecuadorian and Peruvian states. The Wampis Nation includes more than 1 million hectares of our territory. It also includes more than 60 native communities. How does the oil activity affect communities in the Wampis territory? Yes, there are divisions in the communities and in the organizations. Also, there are social disintegration, exploitation of children, and also unequal treatment, persecution to leaders, and threats. There are also disintegration of families. Could you explain to the tribunal what constitutes the persecution that the leaders have suffered? Well, yes, the leaders that defend the human rights of indigenous peoples, in this case of the Wampis, are persecuted through the state apparatus. This is, they are presented to the police and to the prosecutors and eventually prosecuted because of crimes like disturbance, coaction, and other crimes that are included in the penal code of Peru. Have there been social leaders that have lost their freedom because of their protests towards the oil industry? Yes. There have been leaders that have lost their liberty or freedom, but now currently they are in their homes, back at their homes. But yes, and at a certain moment they were deprived of their freedom. What other impacts have been suffered by the defenders of nature and of indigenous peoples because of the oil activities? Family disintegration and abandonment of children, and also a loss, general loss of disintegration of families. Could you explain why families are disintegrated when with oil activity? Because leaders are persecuted, and so they have to flee to take care of their physical and psychological integrity. So that's why they run away from their families to be safe. How many leaders have been persecuted by oil activity? Many, many. More than 10? More than 10, yeah, more. More than 100? Not so many, but more than 10, yes. Yes, that is correct. Could you please explain how the oil industry affects the means of livelihood of the communities? Yes, the One Piece, our market is the river, the forest. And so we, to feed ourselves, we live from the forests. And the fish, when the Lot 64 reactivates, are going to be affected, and also the health, and that's basically it. There are many children that have been affected. We see unknown illnesses. All of this affects or is affected because of oil activity. Thank you very much. I call to the stand Miss Olivia Visa.
Señor Olivia, por favor, explíquele al tribunal.
Ms. Olivia, please explain to the tribunal why you are an ideal witness to provide your testimony. Speaking in ancestral language. Honorable prosecutors, judges of the tribunal. My name is Olivia Visa. I am of the Chapra original people, and I am the daughter of Mother Earth. I was born and raised in our land, in the district of Morona, province of Atemnel Marañón, department of Loreto, in Peru. I am the first woman to be elected president of the autonomous territorial government of the Chapra nation. We are here present because it is our duty to raise our voice, raise the voice of our Mother Earth for her defense, and this defense makes us also defend our lives and those of future generations. Ms. Olivia, this tribunal, International Tribunal of the Rights of Nature, has already made a statement about the case of Block 64. What happened with this? Was it listened to or followed by the state and other actors in Peru? In Lot 64, with a concession that started in 95 and until now, It has 31 years of concession. Out of these, 5 international corporations have tried to exploit this lot. However, the unity of our peoples, like the One Piece Nation, the Achuar, Chapra, and our forces, our strength in the defense of the Mother Earth, made these international companies to uh, leave without success in their intentions of exploitation. However, we have requested from the tribunal that this case of Block 64, we have asked it because of the, we wanted to be annulled, this Block 64, and no further expansion of the oil border. However, the Peruvian state has not listened to this important request that is for the benefit of humanity and the planet. If this tribunal has already made a pronouncement, what would you ask it on behalf of the communities and peoples that live in Block 64? What would you ask of the tribunal in a new statement or pronouncement? Members of the tribunal, in Morana there are 7 indigenous peoples, and out of these, 41 are from the Chapra Nation, 22 of the Achuar Nation, and 33 of the One Piece Nation. However, we want to ask, say that we are the door of the gate to entry, the entry gate to the Block 64, Lot 64. So when they want to go into our territory, they begin with the division tactics of the state itself and also of the oil companies. And also when we come to these kinds of tribunals to demand that the mandate of the people is carried out, we are persecuted. And we were persecuted not only by criminal actors but also by the state itself. Because of being here in these kinds of tribunal, I have been denounced 6 times, and also there were 7 times that there were attempts against my life and my family. But nevertheless, members of the tribunal, it is very important that this case receives a final ruling that for the annulment of the concession of Lot 64, since the claim is placed into the Inter-American Court of Human Rights by asking the annulment of these lots and other lots which are called lots in promotion in Peru. Members of the tribunal, I would like to ask if you have questions for the witnesses in this case. Thank you. And with permission of our presidents, I would like to refer, and firstly, I would like to thank the witnesses for their testimony, for what they have expressed regarding the fact that this project, this lot, there has been attempts to exploit this lot, and it is thanks to this resistance that the project has been suspended in many opportunities. And I think it's important to highlight that this doesn't have to do simply with the expansion of an extractive activity in the territory of indigenous peoples, but it also implies a whole relationship with other territories where these resources in this refinery are aimed. So I think that this tribunal is very important. We can ask what it means for indigenous peoples to decide on a territory when this territory is not simply, like they have expressed, it's not simply a space that is full of resources, but it is a land of life, of memory, of existence of multiple beings. So I would like here to ask, what has it meant, this persistence of these peoples in defending their territory forces us maybe to look at what has happened with this consultation and this consent. that we cannot see it simply as a legal procedure, but as expressions of something that is more profound, the right of peoples to decide on their form of life. So I would like to ask our witness, Olivia, what does it mean for you in this first question? What does it mean that the state has decided to own this territory and destined it to oil activity? And what does it mean for you that you haven't been consulted as you should be when this determines so many decisions on your territory? I would like to if hear you speak a little bit more what this has meant for you that not having consent and adequate consultation. For for us, it is a lack of respect, but it is also a way of discrimination in absolute terms, because we all speak about the great Amazon of the great biodiversity, but we don't consider that this great Amazon and this great biodiversity and the life expectancy and the lung of the world has agents that have pre-existed our governments. It has agents that are sacrificing their life to maintain or to remain as legitimate owners of these spaces. I must highlight, members of the tribunal, that previous consultation carried out in 2012 in Peru did not have the participation of the indigenous peoples, but the state built it in its own way with its purpose of only saying this is going to rubber stamp exploitation. And there is no right for us to decide whether we actually want exploitation to happen or not. Thank you very much to Olivia. I would like to ask a second question that you somehow mentioned in your participation, but I would like you to develop it a little bit more, expand upon a little bit more. If you could give us the name of the if the jungle, the fish, the beings could speak, what do you think they would tell us about what could happen if this extractive activity, were to be reactivated in the land? On Block 64. We as human beings live because we have all our full organs, but above all, the blood. Blood in human beings is what keeps us alive and in continuous activity. And for us, the territory, our rivers, our forests, our pharmacy, our market, our hardware store, and we are not owners of everything that is present there. We are a product of the mother. We are another child, humanity is, of the mother. And in exploiting Lot 64, we would be bleeding little by little our mother. Tell me, members of the tribunal, members of prosecutor, and who are listening to us, is anybody capable of killing their own mother? I don't think so. And many ask how much nature is valued. How much does it, what is its value? Thinking that our territory and our forests have a price. And I would say from here, if somebody thinks like this, they must have then a price for their own life. Because Mother Earth, our territory, our rivers, forests, lakes don't have a price, just as our life doesn't have a price. We have to change our chip, our way of thinking, members of the tribunal, in saying what is more important for us, life or to continue extracting more oil. Can we live without water? Can we breathe smoke? Can we drink oil? Can we eat gold? I don't think so. This presence here in a trip of 7 days is to say, let's be partners in the rescue of our mother, and let's not be accomplices of the destruction of our mother. Let's not be contract killers of our mother. Let's be protectors of our mother. Members of the tribunal, thank you very much, Miss Olivia. Miss Olivia, final question. And I would like to thank you because you all have expressed how your rights have been infringed upon. But this tribunal has an obligation, which is to be able to build new ways of building justice, of carrying out justice. And I would like to ask you, how do you think we can carry out justice when facing all this injustice that has happened in your territory? 2 weeks ago, 5 women of Peru were present in the Inter-American Commission of Human Rights, letting them know and alerting that we as defenders are being silenced little by little. And all of these deaths are being left unpunished in impunity. And we've also asked this tribunal that it recognize our mechanism, our own mechanism of self-preservation, of self-government. And in this manner, we have demonstrated as a Wampis, Achuar, and Chapra nation that our territory are free. But however, the norms that Peru is establishing now are making it so that we are being dismantled legally. Members of the tribunal, we ask you that you have an advocacy, an incidence, so that our mechanism of self-protection, of self-defense, called in many cases according to as nations, indigenous nations protectors of the forest, can contribute to the security and real protection of our territories. Thank you very much. Thank you very much to our witnesses, and I also want to thank our president. And with their approval and the approval of our prosecutor, I think that it's very these testimonies were very proper and timely. Madam President, it is time to close the presentation of this case, and I am going to do it by insisting on what the witnesses have said. There's a struggle of more than 20 years of the defense of the land and the jungle. And this is a struggle that has caused defenders to be imprisoned, threatened, and attacked. This tribunal has already made judgment previously, and this has not been enough. There is a need of a new judgment or a new statement that will move forward very closely, protecting nature and protecting the self-government of the ancestral peoples. This is a step that we have to take. We have to necessarily link the rights of nature with the rights of ancestral peoples that have lived in it, who are their children for ancient times, to be able to govern it, to drive it with the balance that they have learned through the ages. On the other hand, this prosecutor requests that the judgment that is issued be presented to the Inter-American Commission of Human Rights as amicus curiae in order to strengthen the defense of the peoples that they're carrying out in the international space for the defense of their rights. It is necessary also that in this judgment or statement we gather the standards that have been generated by the Inter-American system through the consultative opinions on climate emergency and human rights, where the rights of nature are recognized and where the relationship between the rights of peoples and the rights of nature are recognized. Thank you very much, members of the tribunal. Thank you very much, Dr. Melo, Earth prosecutor, for presenting these two important cases of Ecuador and Peru.
We are going to start. Next, the Rights of Nature Tribunal will hear the case of Colombia of the resistance of the UAS. I give the floor to Dr. Mario Melo, prosecutor of the Earth, so that he can call the witnesses. I request the jury of the tribunal. The prosecutor of the Earth calls Mr. Brito Cubarua as a witness. This witness will make a statement accompanied by his translator and interpreter.
Con su veña voy a
I will now proceed with the questions and interrogation. Mr. Verito, can you please explain to the tribunal why are you an ideal witness to declare on this hearing?
Gavino kakino. Vato yurana niro. Yo. Alberit kuarua. Usar toro. Bemara chirgar. Isai suburi कैसे करते हैं उन्हें वागुर तेता था का कोई वेती शहर तेताई आवाई शहर
Good morning. My name is Verito Curaua. I come from the ancestral territory of the Ua Nation, and I have been a leader for many years now, and I have defended my territory because Syria called me to do so as a mandate to care for our territory, and not only our territory, but the territory of all indigenous peoples. Mr. Verito, can you please explain to the tribunal what is the meaning of Earth according to the UA world view?
तेता तो वहारा वागी ओबिरियामो कामो वहारो काके ये किया ये वो कामो ओबिरियामो वहारो
Padre Sira encomendó
Our Father Sira
para cuidar y proteger
tasked our people to protect and care for our blue planet. That's why I have come to repeat this message before the tribunal and everyone who is listening to us to continue to protect our planet.
cómo
Mr. Verito, what's the impact of oil exploitation on Mother Earth?
kakad witat baroi rawaro konai rawaro bariyao yaro etar kakad witat pagur tetan barsiaro tetara gawa waka al koni yao begaro waka al kutar watira ahat kat batu undo waharo ada sagi hari gente undo waharo
las aportaciones que
The
provocan
way that
las empresas extractivas
extractive companies
minería
affect
o petróleo
mining and
afectan a
oil,
nuestro planeta
they affect our planet
porque
because
ella es nuestra madre, ella es viva
our
y
planet
por
is
eso
our mother,
también
is alive,
ella
and that's
llora,
why she
llora
cries.
las montañas,
Our
lloran nuestras
mountains
selvas,
cry,
nuestras
our jungles
lagunas, nuestros
cry,
ríos,
our lakes cry,
todo el
our rivers
planeta
cry, the
porque
whole
estamos
planet cries, because
afectando
we
todo
are
esto que está
affecting
pasando a nivel
Earth with everything that is happening in the world, and more so in our indigenous communities that have caused these activities have caused the destruction, the earthquakes, and that's why our mother is now speaking to us through everything that is happening in the blue planet. Mr. Verito, what's the concept of the blood of the earth for the UWA?
Tetat wahagro. Asa wa bireta gua wahagro. Ab te kutarito wahagro. Abira kiran toro wahagro. Abwa ki kaki wete kamur bitai si hari auve karwa. Etarabat barshi haro tet ke nasa kawa wakir kar. Aro nihmaru kat batlunga inharo. Jian Bovara nara navan rasa ne kai kuvan. Bana ju ve kayat. Tet vartur bikaro.
In our worldview, oil means the blood of our Mother Earth. Humans can't live without blood. If we extract it, our Mother Earth will also die. And that's why animals, mountains, and rivers and lakes, everything will become sterile and there won't be life for humanity. That's why her, through the Syria Creator, has sent us to care for it and protect it. Because if we do not protect this territory, we won't be able to live. There won't be life. There will be death, desolation, and scarcity. This is what our authorities have told us. Thank you so much, Mr. Verito, for your testimony. I request the tribunal to bring forth the testimony of Ms. Daris Pestancho. Ms. Daris, please tell the tribunal why you are an ideal witness to make a statement in this hearing. My name, Darius Maria Cristancho, in my dialect, Shukana Maraua. I have come here to this space so that I can speak on behalf of my authorities, my territory, because I have been fighting since a very early age, defending Mother Earth, defending Ruira, defending the rights of my people, because we have been violated. I have also had the opportunity to be part of a delegation in Chile to defend before the court all of the efforts that we have conducted, the struggle in defense of our territory. And also I have been a protagonist in the mobilizations that we have carried out in our territory demanding dignity. Ms. Witness, how the defense of the territory has affected the defenders of the earth. The struggle that we have had in our territory has been very cruel because we have had the dispossession of our territory, our authorities, our children through the SMAT, through the use of public force, where children died, where there were many impacts in which we were also pointed out by the Colombian state and targeted, and we were taken to military detachments to the city of Arauca, transported by helicopter. They took us there to prosecute us. And this is a threat to our people because we demand life, dignity, and for respecting
Es así como hemos sido
our
señalados,
territory. We have been pointed out,
discriminados,
stigmatized,
hemos sido
we have
violentadas
been
a
violated
través de la
through
fuerza pública.
the use of public
Y no
force.
solo eso,
And
a nuestros
not only
líderes,
that,
a nuestras
our
lideresas, a
leaders, men
nuestras
and women,
autoridades mayores
our
y a todos
elder
aquellos que
authorities,
salíamos a
and
luchar,
everyone who
éramos
struggled and fought
cuestionados
were
y
questioned
también señalados. Y esto ha
and
sido algo
targeted.
muy duro para
And
nosotros.
this
Por
has been
esa
difficult
razón,
for us.
nuestras
That's
autoridades
why
también
our
han dado
authorities have also
en este espacio
given their life in this space of
para
spirituality,
proteger,
helping us
a la sangre y la
to
madre
protect
tierra
the
todo
blood
lo
of
que nos
Mother Earth
concierne
and everything
en
that
el ámbito
concerns us
ambiental,
in terms of the
económico,
environment, the ecology, and
y la
culture,
declaración de la
and
ley
from
Olimpia
the
y la ley
law of origin
Olimpia.
and the millennial law
¿Ha
perspective.
habido defensoras o
Have
defensores
there
que han
been
perdido
defenders
su
who have
libertad?
lost their freedom?
Defensores que han
There have
perdido la
been
libertad
defenders that have lost
en
their
el caso
freedom.
de los
In the
tres
case of the
indigenistas
three
en el 99
indigenous
que fueron
people in
asesinados,
1999 who were killed
fueron secuestrados y
and
asesinados
kidnapped and
y
killed,
ellos
and
eran personas que
they
venían
were
de
people who
otro
came
pueblo
actually
indígena
from
de
other
Norteamérica
indigenous peoples
y
in
ellos
North America.
fueron
They
asesinados
were
por
killed
nuestro
in
territorio.
our
Estamos
territory because
ayudando
they were
al
helping
pueblo UA a
the Uwa
defender
people
nuestros
to
derechos.
defend our rights.
¿Ha habido
Have
atentados
there
por parte
been
de este
any attacks
instrumentalismo
besides the
para
one that you
los
are sharing with
atentados
us,
sobre
which is very
personas
serious?
civiles
Any other attacks
indígenas
against
en su defensa del territorio?
Uwa indigenous leaders when defending their
Sido
territory?
atacados
We have
no
been
por
attacked, not
organizaciones
my
gubernamentales, pero
organization
sí
as
por la
such, but
Junta
yes, my sister
del Departamento de
in the
Arauca,
department of Arauca,
donde fueron atentados con
where
una
we had
bomba
attacks with a bomb
en el año
in the year
2002,
2002,
donde fueron
where
víctimas
they were
de
victims
esta tragedia que
of
ocurrió
this
en la
tragedy that
casa
took place in
indígena
the indigenous
de
house of
la organización
the
em, de Arauca. Por
the
esa
Arauca
razón, eso fue
organization, and
denunciado
this was
a través
reported and
de los
denounced
derechos humanos.
through
Igualmente también
human
a
rights
las demás
channels, and
comunidades
also
hemos tenido
the other communities
atentados
have
dentro de nuestro
been
territorio,
attacked in
pero no ha
our
habido
territory,
víctimas
but there have been no
como tal.
victims as such.
¿Ha habido defensores
Have
o
there been
defensoras que
any
han sido
defenders that
criminalizados
have been
por este
criminalized
instrumentalismo
and
social?
persecuted by
Yo
justice?
creo en este sentido
I
que
believe that
he sido
I
defensora
have
y he
been
sido
a defender
señalada,
and I have
he
been
estado
targeted, I have
fustigada
been judged,
y de esta manera
and
he alzado mi voz
I have
junto
raised
con mi
my
pueblo,
voice together with my
como lo
people
es Benito Cubarúa,
as
quien
Verita
fue
Kurubarua,
violentado
who
de
was
una
actually
manera
attacked
cruel,
in a cruel way,
casi muere
almost
de
dying
ese hecho y
in.
por eso
That's why
hemos
we have
denunciado ante la Corte
denounced
todas las
before the
violaciones
court
de los
all of
derechos
the
humanos
human rights
ante
violations
este espacio.
in this
Muchas
space.
gracias.
Thank you so much.
Gracias.
Llamo
I
al
call
estrado
to the
a
stand
Aura Teglia.
Aura Teglia as a witness.
Buenos días, Aura.
Good morning, Aura. Please share with the tribunal why you are an ideal witness for this hearing.
Buenos días para
Good
todos y
morning,
todas. Mi
everyone.
nombre es
My name
Aura
is
Benilda
Aura
Tegría
Benilda Tegria
Cristancho y tengo
Cristancho
por
in my
profesión
native
una
language,
hija nacida y crecida en
a
el
daughter
territorio
born in the
Uwa,
territory,
miembro de la
in
comunidad
the
de
Uwa
Guanúa,
territory, member of the
Rauri
Guanua
Uwa,
community, Rauri
perteneciente a la
Ura,
Asociación de Autoridades
belonging to the
Tradicionales
Association of
Guanuenses,
Traditional Authorities that
Cotlahuijala,
covers
Ceteco, Comunidades
19
Unidas,
communities
en los
located in
cuatro
the
departamentos
four
de Casanare,
departments of Casanare,
Boyacá,
Boyacá,
norte de
the
Santander,
north
en
of Santander,
Santander,
and Santander
Colombia.
in Colombia.
Por favor, cuéntele al
Please, can you
tribunal
please tell the tribunal what was the struggle that led the UA to obtain a favorable judgment by the Inter-American
El
Human
pueblo
Rights
de la
Court?
nación Uwa de
The
Guanúa
UA
conoce
nation and
de
people
mucha
in the framework of
resistencia
the
en
struggle
defensa
and
de Ruiz
resistance in
Casado,
defending
nuestra
Ruy,
madre
the
tierra,
blood of Mother Earth,
ha llevado
has brought to the Inter-American human rights system the systematic violation of collective rights and human rights violations of the UA people. That's how in the year 1997 we installed the petition to the court, Inter-American Human Rights Court, and because of the presence of destructive companies in our ancestral territory, the pipeline that goes through our territory, where this was done without consultation and violating our collective and territorial rights in the year 2015. They actually admitted the request petition to the system, and later in the year 2024, June 4, 2024, the Inter-American Court issued a ruling on these violations and facts condemning the Colombian state. And we need to highlight two very specific orders for the UWA people. First, the one that has to do with the full repairment of the UWA territory, since for more than 20 years the UWA people has lots of property in land that has not been recognized with titles. And the second measure has to do with respecting the protection and safeguards of our Insisuma, which is the Cucuy mountain range, the Sierra Nevada, the National Park of Cucuy, where they determined an area as a national park without any consultation and taking into account our worldview. This is an area where we find the foundations of our larger house, where memory inhabits, and where we find our spiritual and sacred beings that drive our connection with the spiritual world and spiritual worlds and the physical world, and where our traditional authorities send a communication channel and send messages through our spirits so that we can create balance and survival of our Mother Earth. The reparation measures ordered by the Inter-American Court, were they fulfilled in the case of the UA? We have to say and state in this regional tribunal for the rights of nature and the jury and you, prosecutor, that they have not complied fully the 12 orders of the judgment of the Inter-American Court. Only in 2 years they have only complied with one of them, which has to do with the public action of apologizing made by the former president of the Republic, Gustavo Petro, in Yuba territory, but the other orders of the judgment were not complied with. That's why the UWA, after 2 years, we are concerned that they have not complied, specifically in terms of the full sanitation, healing of this territory, and in terms of Sisuma, our park and the National Park of Cucuma. What do the UWA request from this International Rights of Nature Tribunal? At this point, Colombia is going through a very difficult situation and a reactivation of the extractive engine. And the arrival of the new president, Eduardo de Espriella, puts at risk the survival not only of the UWA, but also of all of the indigenous peoples that have defended our Mother Earth. And that's why we ask this tribunal and the honorable judges to have a positive impact and advocacy with the Colombian government with the compliance of the orders of the Inter-American Human Rights Court, as well as the protection of us as leaders and defenders of Mother Earth. One last question: were you ever consulted and gave your consent to oil activities? The arrival of oil companies was done without any consultation. The arrival of Occidental Petroleum in the 90s violated our territorial rights and human and collective rights. There was never a consultation process. In the year 1997, the Honorable Constitutional Court in Colombia issued a judgment ordering the prior consultation to the UWA. but there was no process like that implemented. They only filled out attendance list and requirements like that, but we have a possession on this. We are not the owners of our mother. On the contrary, we are the guardians and protectors of Mother Earth, the blue planet. And to date, the establishment of oil wells of Gibraltar 1, 2, and 3, they were established without any consultation. They are taking our gas, our natural resources, for more than 20 years. The installation of the pipeline that goes through our territory was also installed without any consultation, as well as the Magallanes AP, the Magallanes well that was dismantled in the year 2015, thanks to the struggle that we conducted. This is also being reactivated, as well as the Morfeo well. None of these were consulted. I ask the jury if you have any questions to the witness of this case. I request the permission from the president and the members of the jury. I ask the Aura witness, what has been the implication of the ruling of the Inter-American Human Rights Court, and what has been the actions after this sentence? Well, it's a beautiful achievement of the people, a result of the resistance and struggle of our authorities and leaders and wise people, our grandfathers and grandmothers, that sets a precedent in Colombia, not only for the UWA, but for the rest of indigenous peoples in Latin America, where they recognize the rights that we have in our territory. And of course, it also implies making progress, but we know that this struggle doesn't end here. On the contrary, just as you have it here with our brothers and sisters of the Sarayaku people, a constant struggle after the judgment for the state that has been condemned to comply with the orders of the sentence. And we also see that after 2 years, it has been extremely difficult, and we need to continue with the strength of our authorities, with the strength of our spirits, and sitting us and tetting us, so that the Colombian state may actually respect the territory of the UWA, to respect our Caiga, and so that we can actually live in peace and harmony with our spiritual beings. Ms. Aura, we know that the council actually went against a license in Magallanes. You proved that you were not consulted and you had no prior informed consultation. What was the process to explain in terms of explaining this to the court? The Magallanes well is a well that was installed only 100 meters from our sacred river, Curoa. So it's a sacred river where, I repeat, this is a communication channel between worlds, the physical and spiritual worlds, that maintains and keeps the balance, and we have the blood of Mother Earth there. And this was given in concession without any consultation, and in the year 2013, through the Congress of the UWA people, we determined the reactivation of the struggle and resistance in the territory, and we achieved with a team with Amazon Watch, was International, and many other colleagues and allies of the UWA people, were able to carry out an analysis of the environmental license given to this Magallanes well, showing the impact to our sacred river, proving that they had made it invisible because the Ministry of Interior stated that in that sector the UWA didn't exist, there were no indigenous peoples there, and we were just crossing the river 120 meters away. Our homes were there, our families and children were there, and we proved that we were there and that there was no consultation process. Thank you. Now, the Earth prosecutor is going to close this case with a reflection. This case shows us the deep spiritual roots that the defense of the territory has in ancestral peoples of the Americas. The case of the Uwa people is an emblematic case that we have that the different defenders of human rights have followed throughout the continent and all over the continent. And I have to highlight that even though there was a legal victory in the highest justice tribunal of the Americas, this judgment was not fully complied with. For these reasons, the prosecutor requests the tribunal to support the full compliance of this judgment and for it to be presented to the Inter-American Human Rights Court within the process of compliance of the UA case so that we can strengthen the position that the member states of OAS must be obligated to comply with these judgments that condemn the violations of human rights. Thank you so much.
Muchísimas gracias.
Thank you to Dr. Mario Melo for presenting the UBA case in Colombia. Next, we'll hear the Venezuelan case in the peninsula of Bananá in the Falcon State. Mr. Prosecutor. The Earth prosecutor, with the permission of the tribunal, requests the presence of Mr. Emiliano Terán to provide his testimony. Good morning, Mr. Emiliano. Please tell the tribunal why are you an ideal witness to provide testimony on this occasion? Well, good morning, everyone. I am part of an environmental organization in Venezuela, the few that we have in the country that has conducted an analysis monitoring systematic study of the impact of oil in the territories, in all of the territories where the industry has been developed. And we have carried out a follow-up in a very close manner. And we have offered information, systematic and public information for the access of the population so that given the complete absence of information on this matter, this has not been an easy task in Venezuela. And in my personal case, I have been investigating the Paraguaná case for more than 14 years in the framework of my research as part of the research conducted by the university in Venezuela.
Mr. Witness, in the case of the peninsula of Paraguaná, it's a sacrificial zone. What is that concept? Yes, the Paraguaná zone was set up as a refinement pole, the main refinement pole for decades in the world, where what we can see there, we're talking about the end of the 40s until the present, is a situation of a persistence of environmental impacts that have been completely moved in completely impunity and have created in the area a normalization of the sacrifice of all the tapestry, both social and ecological, that exists in that peninsula. What are the persistent environmental impacts in the region? Well, there are several. We could mention at least 5. The first has to do with exposure to the flares. Not only do the communities mention that since the flares are working 24 hours a day, they have permanent noise and permanent heat, but also we have gathered testimonials where in a street there are several cases of cancer since this street is next to a flare. There is there's very little scientific evidence, but there are some reports that have been filtered. They came from internal reports from Petróleos de Venezuela, the oil company of Venezuela, that have mentioned that besides what emanates from the flares, there's a presence of gases like H2S, sulfur components, and heavy metal levels in the air much higher than is allowed. This, and to add to this, we have the several chemical spills. The communities have denounced several kinds of illnesses. I mentioned cancer. I also mentioned there are also respiratory, skin diseases, and neurological diseases. The last visit where we were present, they shared a paper with us that was published that linked the exposure to chemicals with the incidence of children with autism in the area. This caused that for some years back, the community set up a committee, a health committee, and from this committee, they demanded both epidemiological studies and and actions to be taken because of the illnesses that they have lived through. A case that has been reduced because of the collapse of the industry is the presence of coke, which is a subproduct in heavy oil, but that when accumulation creates a little dust that is breathed in by the communities who have mentioned linkages to respiratory diseases and the occurrence of black rain in their backyards. We have accidents also that have been recurring, especially after the collapse of the industry, but there is one that is a flagship one, which is the explosion of the refinery in 2012, a gigantic explosion that cost 48 deaths and 151 people injured. By then, after the collapse of the industry, the smaller explosions and other accidents were constant. And I want to make a final emphasis on oil spills because these have caused the greatest social conflict at least since 2019. We're talking about spills that occur in the small Gulf of Coro in the province of Paraná. This is a constant presence of these spills from the underwater pipelines, undersea pipelines that have severely affected fishery, since the communities of these areas are fishing communities that depend a lot of the activity, even more so with the economic crisis that Venezuela lives, and this has generated the at least partial disappearance of fish in the Gulf, and they have had to move to fish much deeper, further into the sea, and this of course increases costs, reduces their margins, and species like merluza, sea bass, or corvina have been affected, and same with shrimp, king prawn, and other kinds of products that are very important for them. Given the critical situation, humanity's situation of Venezuela, the impact to food safety and food security has been severe, and this comes, we can see not from interviews, but from the strong protests that come from the communities of this area that even cause some impact in the media. And we can talk about the community of Rio Seco, Mitare, Tiguadare. They denounced the situation, the very grave impact in their systems of family feeding, and the economic impact and the importance that of demand, which was the cleanup of the Coro Gulf. I would like to close by saying that It's possible that the Venezuelan case is the case related to oil that has the greatest level of impunity in all of the American continent. And we have a normalization of an oil disaster that has been installed for decades in the population. This obviously makes it so that we could say that in the case of Paraguaná, same as the Lake of Maracaibo, probably these are some of the more representative sacrificial zones in all of the history of oil. I would like to call to the stand to Eric Camargo as a witness. Mr. Camargo, why are you an ideal witness for your testimony to be heard in this tribunal? Thank you for the invitation. Just as Emiliano Terán, I belong to the Observatory of Political Ecology in Venezuela, where we have been working as a team in the research and dissemination of the social environmental conflicts in the country and monitoring spills and other incidents in Venezuela. In the particular case of Falcon, we have several years working in the area. We have contact with the communities, with uh, journalists, and we are constantly receiving claims directly. And we had a visit of the Oil Watch, where we did a toxic tour through the zone, and we exchanged experiences with the fishermen and with the community. Mr. Witness, what are the impacts of the oil activities in the communities in the zone? Well, in this case, the main defenders of nature and the main people affected are the fisher that obtain from the Gulf their main sources of livelihood. They are also the ones that first see the spills and see the problems and denounce them. They have been criminalized, persecuted, and sentenced. There are some flagship cases that are relatively recent. One is a journalism piece where one of these fishermen say that in October of 2025, in the blockage that was put by Trump in Venezuela, where they were bombing boats, they were more scared of being persecuted by the Venezuelan state because of their claims than being bombed by the Americans. And the second case, which is super recent, in this 14th of August, a few days ago, 3 fishermen were condemned to 6 years because of terrorism. They were stopped in September 2024 for protesting against the oil spills. We've also seen that the compas, which are the organizations that the fishermen use to organize themselves, have been intervened and politicized by the state. They've been divided in 2022 when we have the visit of Oil Watch. We had an assembly with these fishermen, and they warned that the national authorities were uh, aware of the visit and the meetings that were happening. And we have seen how these groups have been divided, and they have generated conflict between those who align with the National Institute of Fishery and those who are denouncing the spills. Regarding the press, which, which can help the fishermen to denounce, we have seen systematic persecution that has its main antecedent by the stop of journalist that was stopped for reporting a spill in the area. We have also seen an increase in the persecution to the press, and any news that are denouncing spills imply carry with it jail. And the Division of Military Intentions of the Army, they stopped several journalists. They seized their phones, deleted the information, and they forced them to delete from their computers and memories all the information they could have on oil spills and on the refining complex. The policy of state in general is denial, or the waiving of responsibility. They always seek some other guilty party or they deny the impacts of what is occurring. In this way, even the urban communities surrounding the refinery have also been persecuted for denouncing the affectations. Recently, we also have the case of PDVSA Obrero. This does not have to do directly with pollution, but it does part of these workers, 119 workers that were detained last year in PDVSA. They have denounced corruption and lack of maintenance. 30 are work in the refining complex. Some of them told us direct facts about how maintenance has been reduced of the equipment in the refinery and how they have stopped working with treatment plants have they used to, and they have returned contaminated water into the environment. Also, neighbors of Judibana, which is next to the Amoy refinery, denounced that the water that they use that comes from the in the public water system comes with a oily film. Last year, also the Institute of Scientific Investigations and Research of Venezuela, they sent some specialists that studied the impact of all of the situation on the Gulf of Coro. Unfortunately, this study has been unable to be published, and the specialists who did this work have not wanted to talk about this issue to the press or any disseminators or anyone. So there's a fear and self-censorship about this issue. PDVSA has always been, since it exists as a company of the state since 1975, has been seen as the economic support of the country, the source of prosperity of Venezuelans, and therefore the policy of state is to protect it and defend it at any cost, no matter the environmental problems that it can show. And this has made it very difficult to denounce and to fight against the authorities of the state or against its bad management or bad practices. I would like to ask the tribunal if they have any questions for the witnesses. We now give the floor to our co-president, Gregorio Mirabal, for any questions. Speaking native language. A greeting to everyone, brothers and sisters present. I want to, it's my first participation. I wanted to congratulate the all indigenous brethren present in this tribunal for the rights of nature, for their dignity, for their bravery and knowledge, they are fighting for our land, our brethren from Ecuador, Colombia, Peru. From this position, I offer my respect and admiration. This tribunal began also with a lot of pain because of the murder of an indigenous authority in Venezuela. He's not the first. I have more than 50. There's no records. In our territory, the Amazonas state, our organization, a regional organization of the Amazonas people, has made several claims. We have identified at least 4 or 5 murders in the last few years, and in this context, we go to the region of Falcon state with this case of the witnesses. Within the framework of more than 100 years of oil exploitation in Venezuela, what are the arguments beyond the spills, beyond the pain that indigenous peoples feel where their rights are infringed by extractivism? What are the impacts in this moment beyond the Gulf of Coro? What is the impact in nature, in living beings who have been contaminated, polluted by oil, and all of that the oil brings to fish, to water, to humans. And what would happen if all of this continues in impunity? Unfortunately, there are no scientific data that can be verified on this situation of persecution, but what we have can clearly see is that the Gulf of Coro is a place where fish go to lay their eggs. It's a reproduction area, and we have seen how more and more there's a reduction in the fish quantity. So beyond the affectation to humans directly, the affectation of nature, we have seen how there's a considerable reduction in the species of fish that inhabit and reproduce in the Gulf and in the Caribbean Sea at large, that have exchanges with other ecosystems. And so they are being exterminated. So if does not stop soon, the Gulf of Coro is going to be a dead area without fish, without crustaceans, without fauna. But it's also being affected. There's also affectation in the coastal vegetation and the whole system that is nurtured by the winds. And if the Gulf of Coro is affected, it's going to affect how all the ecosystem, both marine and land ecosystems, are going to be affected. We're talking about several interconnected ecosystems that are being affected and are being degraded with all this activity that has to be stopped. The water of these seas is more and more contaminated, filled with hydrocarbons, and obviously this affects the capacity of the sea life to live there, to reproduce, to be healthy. Also, there is danger of the degradation of the dry area of Paraguana, which has already water scarcity, scarce in fauna, and has, with this pollution from spills and flares, we're also seeing a reduction in land fauna in the area of the refinery. So animals are being directly affected. The water, the little water that exists, makes it is unviable. Population uses water that is extracted far away, and this is enormous expenditure of energy. So we're seeing that there's a considerable affectation to the Gulf of Coro and all the areas of the Caribbean that are surrounding. And the dry and semi-dry area of the north of Falcon, the province of Paraguaná, and this area of Urumac. Thank you. It is my... Now I have to close the reflection about this case with something. The key concept in this case that has been presented is of the sacrificial area. This was defined by one of the witnesses as an area in which the environmental impacts accumulate in such a way that they become normal. And these affect not only Mother Nature in the sea, in the species that live in the sea, but also fundamentally the human communities whose quality of life is severely deteriorated. They lose their livelihoods, and this is also linked to a series of manifestations of violence, the suppression of the right to free expression, criminalization, and persecution of defenders. So this case raises the alarms of how far we can let oil activity reach when it goes beyond the rights of nature. Thank you very much. Thank you very much, Dr. Mario Melo, Earth Prosecutor. Next, we have the case of Bolivia in the reserve of Tariquia. Thank you very much, Mr. Prosecutor, for calling your witnesses for this case. With the approval of this tribunal, tribunal, I ask Francisco Romero Lopez to the stand. Mr. Romero Lopez, please explain to the tribunal why you are an ideal witness to provide your statement in this tribunal. Mr. Prosecutor, members of the tribunal, and audience present, my name is Francisco Romero Lopez. I come from Tarija, Bolivia, and I consider the ideal person to let you know about the of the case of Tariquia because I was born, I raised, and I live in this natural area, which is considered as a protected area of the Bolivian state. I've also been the promoter of the first march for this reserve in 2017. I have also been considered and elected as a representative for in the legal processes to defend Tariquia, and I have presented two popular actions asking for a consultation for Decree 2366, which opened the doors to the oil companies to go into not only into the reserve of Tariquia, but to all the protected areas of the Bolivian state. I've also presented this case to the United Nations in 2018 in Geneva, also to the Inter-American Commission of Human Rights. That is why I feel that I am legitimate delegate to this tribunal to let it know about the infringement of the rights of our nature in our country. Mr. Witness, please explain to the tribunal how the oil activity affects nature in the Tariquia Reserve. Thank you, Mr. Prosecutor. Well, the reserve was created through a law in 1990, and this has objectives why it was created, which are to preserve the last part of the rainforest of Yunga, Tucumán, Bolivia, and also as its main objective we have the preservation of its large basins of the Tarija River and the protection of these inhabitants within this protected area. But despite all of this, the government has created 3 oil projects for this within this protected area, which are the Astilleros Churumas and Santelgu Norte blocks. In the Astilleros block, they have come in with a well. They started exploration of a well, but there's been a failure, and also entered through that zone to do the Churumas wells where they are already functioning. And the environmental impacts in this area are, according to the the information that we have gotten from the National Service of Protected Areas, according to requests, is that the companies do not comply since there is demands in the area. They don't comply with the protection grids or fabrics that protect the contamination of the land. This company is not complying, and we have the protection of the ravines and the roads. The company is not complying with protections, and also the affectation of this area. Since it's a protected area, there's a zoning, and they have altered or modified the zoning of the reserve. They have reduced the category of the core area to, they have reduced the protection area to where it is also prohibited to do extractive activities. Another affectation is that in this area that is better conserved of the reserve, we have a huge number of animals that are endangered species like the jaguar, the tapir, the bespectacled bear in the Rio Grande of Tarija. And despite all of this, we still have oil projects that for us for the state do not signify anything. Only thing what they are interested in is to get money out of it, with the supposed intent that with that the Bolivian state is going to get out of its financial crisis. In this protected area, we also have the third block, the San Telmo Norte block, which is located in the Chiqueca, where which goes throughout the reserve of Tariquia, with X1 and X2, thanks to the central in the Tariquia section. We have been able to stop it. They created the XIII well, which is in the area of influence, in the buffer area, but they are in the head of the river Chiquiaca, where we have so 10 communities living there in the lower area. They live from agriculture and cattle ranching, and they drink water from these ravines, and there's imminent danger of pollution and of desertification of their production. Among them, we have many other activities or risks that endanger this protected area. Thank you very much.
Llamo al estrado a la testigo.
I call witness Zoraide Farfán to the stand.
Señora testigo, por favor.
Madam witness, why are you an ideal witness to make a statement in this hearing? Good morning, the judges and prosecutor. I am an ideal person because I was born and raised within the Tariquia Reserve, and I know well of the problems that the company has caused. Let us know precisely what are the infringements or attacks that the members of the reserve have suffered. The communities and the defenders of Tariquí were gravely affected. Firstly, Petrobras and YPF, they came with promises and falsehoods to our communities in Tariquía, and they divided all our organization. And then they criminalized us with 29 prosecuted people, where in the investigation 12 defenders have been charged, and we are going into a trial. After this trial, we were absolved on any responsibility because the only thing we were doing was to defend our territory. And later they denounced several other of our colleagues, and this did not prosper within the justice system because there was any argument to find us guilty of any crime. Later, there were direct clashes with the police, which was protecting the company. They harassed us. They have also called us to make statements in front of the police. Sorry, I'm nervous. Thank you. I would like to thank very much for the testimony of the brave person that has come to the stand to tell us of our truth, of her truth. I would like to call to the stand Mr. Albino Mercado.
Señor Ali Albino, dígale al tribunal.
Please, can you please tell the tribunal why you're an ideal witness here? First of all, good morning, everyone, the judges, the tribunal. I was born my name Ali Albino Mercado. I was born in the Flora and Fauna Reserve in Flora and in Tariquia, in the south of Bolivia. I'm the ideal person to present our case, which is a very worrisome case, as my colleagues mentioned. Petrobras pretends to explore within our reserve. How will oil production affect the reserve and the communities living in the reserve? Well, they have already affected them once and again. To our communities, the living organizations in our communities, we are peasant communities, and they have divided us. We have fought among ourselves, and also between fathers and children. They have divided, and families were divided. It's very concerning for us. I want to ask you something. How is it possible that if the Tariquia Reserve was declared to protect nature, at the same time they authorized oil projects inside of it? Isn't it a contradiction? Yes, it is contradictory. Instead of protecting protected areas, the state is actually facilitating the entrance of oil companies that will really affect the Tariquia Flora and Fauna Reserve, which is one of the best conserved in Bolivia. The first impact would be that they will be entering on the north, where we see the springs, water springs that feed the Chichaca municipality, and this water ends up in the Tarija River, and the Tarija River is later going into the Republic of Argentina. I would like to ask you, what are the implications to the families of the communities living in the reserve, the fact that brothers and sisters, children, fathers may be criminalized and persecuted for defending their territory? Well, first of all, we were very united at the beginning as the Chichaca municipality. When they wanted to go in as Petrobras, everyone went out to say no. And so we even have even two votes at the municipality level saying no to the entry of oil companies. So yes, they do criminalize some of our members of the community so that we want to go out and fight the companies so that we will let them enter freely. And this has affected us organically, organizationally, at the family level, and we are divided. Thank you so much. I ask the tribunal if you have additional questions for the witnesses. Yes. I would like to ask you, since this is the last witness, and these are farming communities, peasant communities, is there a meaning that you have and feel especially towards the national park? How do you feel in relationship to the national park, emotionally speaking, the relationship you have with the Tariquia National Park? And the second question, just for you to have a time to respond, what are you requesting from this tribunal? Well, we feel blessed because we live inside paradise, we can call it, within the Tariquia Flora and Fauna Reserve. And we live from agriculture, livestock, apiculture, and this is the reason why we are defending the Flora and Fauna Reserve. And my request to the tribunal and to the judges is to demand or raise alerts to the authorities in Bolivia, international companies such as Petrobras, to respect our rights as environmental defenders, and also to respect the Escazú agreement, which we are part of. They never respected that agreement, and they have no intention of respecting it. Thank you. I have now to close the presentation of this case as prosecutor of the earth. and I propose the following reflections. In many of our countries, unfortunately, there are schizophrenic states governing that have double or multiple personalities. That is, one state that considers that a natural space, a life space, must be conserved for present and future generations, declares it as a national protected area. So that's one of the personalities of looking at the relationship we have with nature. But at the same time, the same state then thinks that we need to take petroleum from these areas, which is an activity that we know that destroys nature. And in the same place where they created the reserve, they also created 1, 2, 3 oil-producing lots or blocks. So this contradiction makes public policies to be inefficient, and the communities that live in this rich natural environment full of life are affected and be persecuted, and they destroy their social fabric and make people suffer by being persecuted, because what actually commands here is the interest of making a profit, making money. So the defense for the rights of nature and the defense for the rights of these communities is not a gratuitous defense. They pay it with their life, with their peace, the peace of the community. The communities that are being affected by this type of project and have the dignity to raise their voice and stand up in defense of nature. Thank you so much.
Muchísimas gracias al doctor Mario.
Thank you so much to Dr. Mario Melo and his team for presenting these cases as Earth prosecutor. We will be calling you for the final argument after the Amazonas case, but right now we'll be hearing to the FOS de Amazonas case with just one consideration. This case will be mainly in Portuguese, so we ask people who still don't have equipment that are not bilingual, and we're going to make a translation here so that you can pick up with your ID, please, to pick up a headset, those who are not bilingual or do not understand Portuñol. It is necessary for you to pick up your translation devices. We have enough to hear the case and also to hear this case. We ask Dr. Ramiro Avila Santamaria and Dr. Fatima Monasterio to be able to present themselves as prosecutors.
Por favor, les pedimos que no tomen mucho tiempo. ¿Están listos?
So the translators are ready to so that this transition to take place and start quickly with the Amazonas case.
Galo, Galo.
No, tranqui. yo no quiero.
Sí, yo tampoco quiero.
O sea, es que ya les he escuchado, entonces no importa. No importa, no, por alguna razón que no entiendo. No, portuñol.
Les pido que vayamos regresando con los equipos.
Please come back with your devices so that we can start with the case.
¿Qué dijo ahorita la Nati?
Si me confirman afuera.
Can you please confirm if there are people waiting for their devices still outside, or we can start?
Vamos a empezar entonces el caso de FOS de Amazonas. Como había explicado anteriormente, cuando pude...
So we're going to start with the case of Foz de Amazonas. When I read the biography of Dr. Santa Maria, please, can we keep quiet? We are going to start. Please be seated. As I explained at the beginning of this tribunal, both prosecutors of the earth went to Brazil to learn on site about this Foz de Amazonas case. So I give now the floor to Dr. Mario Avila Santa Maria so that they can start with the questions on the case. Thank you so much. Madam President of the Tribunal and members of the Ethical Tribunal on the Rights of Nature, peoples that accompany us here today. My name is Ramiro Avila Santa Maria, and I'm appearing here together with Fatima Monasterio on behalf of the Amazonian coast to denounce the threats and violations to the rights of nature provoked by the opening of exploration and exploitation of oil in the marine coast. Our presentation will have several parts. One first one, I will give the floor to Fatima Monasterio so that she can present the context and background of the case, and then we'll be practicing the proof of the case, and then a final closing argument. Good morning. Good morning, President, jury, members of the jury. The coast, the marine Amazonian coast, is a complex network of life systems that work thanks to the relationships that we have between the river and the sea. In these coasts, we have mangroves, estuaries, and the Amazon's river enters with force into the Atlantic Ocean, and it creates the Amazonian plume. And this is the extreme north of Brazil towards the Guianan territory. And the prosecutor would like to clarify here that the Amazon doesn't end in the line where the river reaches the ocean, but it rather continues much longer into the coast, and it creates life systems which are essential to be able to guarantee the rights of this subject. In this coast, in this sea and river at the end of this river, there are hundreds of communities, fishermen, traditional communities, quilombolas, and there are also 4 indigenous peoples that live in the municipality of Oyapoque that will appear before this tribunal to show the violations that are happening, giving the opening of the oil frontier here. I ask to show a request to show the first image to show that in the year 2019 the Brazilian state published its national energy policy, where they were offering 47 oil blocks in this Amazonian marine coast. And they did it in an area that they called the sedimentary basin of Foz de Amazonas, to give it a name to these interrelations that we find aimed at opening the oil frontier. What you can see here is just one of the blocks which in the year 2025 obtained an operation license, and you can see it on top of the image. Block 59 has one well, which has been authorized to be drilled, and at this moment, right now, when I am addressing the floor, is being explored. This is the Morfo well. Morfo is a network, is not one point distant from the coast, because what you can see in the image is actually, on the one hand, a marine bed that works in Marén do Pará, and another, an air base that works in the municipality of Oyapoque, creating this network where the vessels travel, where aircrafts travel, and this is how they are altering the cycles that made it possible to have life in the Amazonian marine coast. To show these violations to the subject of rights, presidents, I would like to call to the stand to the leader XII Monono
por favor, para que pueda
so that
contarles
he
ella
can
también
share firsthand how
las comunidades
the
de vida
communities,
que
the
forman parte del
life communities
ministerio
that are
que
part of this
hacen
subject of
y
rights
también
that
que
are also
reproducen la vida
reproducing life
puedan contarles de primera
can
mano
share with
qué
you
es lo que están
firsthand what they
viviendo
live
en
and
este
experience
lugar tan
in this
biodiverso que
such a
constituye nuestra vida.
biodiverse place. First of all, I would like to greet all of the judges of I am the leader XII Marono. I am coming from the Gaudi Marono ethnic group of the Garibalosa indigenous territory located in the extreme north of Brazil. I am here leading my organization, the Organization of Leaders in Oyapo, where we represent 67 villages in these territory, 3 indigenous lands, and our indigenous reserve, the Wasa indigenous land. We have 470,164 hectares occupied by, inhabited by populations from 14,000 indigenous people. And I'm here representing my people in this tribunal. Thank you for presenting yourself to the tribunal and expressing the authority you have to present this case. When this prosecutor of the earth was in Oyapoque discussing with indigenous peoples, we heard about the story of the origin of the rivers that go through your territories. Can you please share with this tribunal the story of the Wasa cobra? Our ancestors have lived in this territory for thousands of years, and our worldview talks about the wasa boa or snake that came in from the ocean to give birth to 2 children, which entered our territory, and so one of them was stayed there and was the origin of one of the first rivers, which is the Curipi River. And later, they continued and gave birth to a son that is the origin of the Rukawa River, which is called the Jurukawa River, and it kept going, and over time the cobra continued, and they stopped at a given place at the head of the mountains, at the top of the mountains, and this created the origin of the Wasa River, which is a sacred river for us. Thank you, Leader Giselle. Can you please share with the tribunal how is this territory like? Our territory currently it is bathed by the ocean, where we have a river. There was a river. And there was a basin, which is bathed by fresh waters, where we have flooded fields. We have 3 large rivers and mountains. And for us, it is very important in terms of ancestral people of this region that we have been there hundreds of years and live there. And we have a biodiversity of animals, of fauna in the rivers, birds. How is the relationship of you have with the territory and the elements that comprise these elements from the cultural point of view, the spiritual point of view? Well, we, as I had said, thousands of years ago, our ancestors and people that came before us, we have always had a relationship with nature, because nature for us is sacred. Our rivers are sacred, our forests are sacred, our lakes are sacred, and this is where we take our means of life. where we live. We live in this region, and the fish that we have are fish that come from this river. The water we consume is water from this river, and nowadays we are here being led by our organizations to claim and defend our territories, and whenever possible, we will defend it with our life, even if it's possible. What's your request from this tribunal? Hopefully, this tribunal can actually come and help us and defend our territories, and it can. Hopefully, they will come to defend and protect our territories, because for us, nature is life, is a source of life for all of us in this region. And we ask this tribunal to help us fight the problems that are coming to kill life in our territories. Mr. President, Madam President, I would like to call to the stand Leader Wagner Karikuna. Thank you.
Señor testigo.
Mr. Witness, can you please address the tribunal and state your name and the authority you have to speak on this case? Good morning, everyone. My name is Leader Wagner. I come from the Caripuna people of the Ayapoki state municipality, and my country is Brazil. I come here to represent my people, my municipality, my state, precisely because I come from a leadership hierarchy. My grandfather was one of the biggest leaders in my people, and now I and my father as well. I'm very honored to be present here, representing not only the Caripuna people, but also the three ethnic groups that are part of our territory. Mr. Wagner, do you recognize the oil project in the Block 59? Look, I know a little bit about this project. We know that this project is from the beginning. Some years ago, we were concerned about it because we are not used to this type of action undertaking that arrived to be installed in our territory. So we were very concerned from the beginning. We know the problems that they can cause inside our territory because our population is almost invisible in terms of this process, how this process was undertaken. Can you please share with us what is the impact that you are feeling with oil exploration?
Yes, the impacts that we as indigenous people have been suffering are precisely because of the starting with the announcing of perforation in the Amazon basin. They know that it's going to go in a great scale. I think that the impacts starting happening already. For those who don't know it, the our municipality is quite small, but in our territory is small, and so it coincides with the announcement of Petrobras. There's a lot of people within the municipality of Oiapoque, and before this, the municipalities grew a lot. The number of people, the population grew a lot, and they began having 7 new neighborhoods within the municipalities. Saying we don't have now where to grow. We don't have the mayor continues to give out land. So this surely will quickly, these people are going to arrive to our territories. So this is a big concern that we have, are already suffering. And not only that, but we know that the arrival of these new neighborhoods, of these populations will bring drugs, trafficking of children, women, animals, because we live in a border area with French Guiana. So this is of great concern, and we know where they're building the platform, the oil rig. It's 170 kilometers from our territory. It's very close. It's not that so what happens is that the tide goes into our territory, so we are concerned because what happens is that within the Guasá River we have fish, and these fish will be start to disappear. And also within our territory we have a reduction of flora. We have a national park where a lot of with a lot of marine life, and where we also get our subsistence with the seafood. And all of this is of concern for people in the last few years that we've been coexisting with these activities. What do you request from the tribunal? I would like that they do to make a big request for the tribunal to bring this, to continue this forward, that they don't stop, because in this moment we are not yet achieved to have a significant response, because we are continuously asking for consultation, and now the Brazilian government is not doing the consultation. And so we would ask the tribunal that they listen to our reclamations, our demands, and bring them forward, because maybe like this we can obtain our objective with transparency for our territories. Thank you very much.
Señora Presidenta del Tribunal, antes de llamar al...
Now we're going to call our following witness, which is Nelson Bastos. I would like you to let us show a video that makes us see and feel the place that we are discussing in this audience. Please, I would ask the Secretariat that you proceed with the video.
Nós estamos num local aqui, que é um local para nós muito sagrado e muito significativo, que é um território que envolve nossas comunidades tradicionais, território ancestral dos Nhengaíbas, dos Aruãs, dos Sacacas, dos Ioanás, foram povos que viveram aqui.
O meu pai, ele é pescador. A pesca aqui na nossa comunidade é a principal fonte de renda.
E é o paraíso, porque aqui a gente bota nosso material para pescar, tem nossas canoas, nossos portos. E a vivência, a vida é essa. E a nossa custo de vida aqui em Soura, aqui na nossa área do bairro que a gente pesca, é baixo. Então, com a alimentação sendo bem próspera, o dinheiro que a gente precisa é para pagar água, luz, internet e sobreviver com o dinheiro do peixe. A gente faz a venda, compra, revende.
A água nos dá o sustento à vida, que é o peixe, que é o nosso alimento, que é a nossa proteção.
Eu fui criada com a pesca.
Aqui, isso aqui era farto, dava muito peixe aqui.
A gente cria aqui nossas condições de viver harmoniosamente. E hoje, essa harmonia ela se quebra. A gente cria aqui nossas condições de viver harmoniosamente. E hoje, essa harmonia ela se quebra. A gente cria aqui nossas condições de viver harmoniosamente. E hoje, essa harmonia ela se quebra. A gente cria aqui nossas condições de viver harmoniosamente. E hoje, essa harmonia ela se quebra.
tem vezes que passa de 10 navios no dia aí.
O barulho, o lixo que eles trazem afeta o pescado.
Você acha que nisso o peixe vai ficar? Não fica.
Não tem mais, né? Aquele esforço, o gasto com combustível para ir lá e não tem, né? Não tem essa volta, porque os peixes já estão longe, não estão mais aqui como antes. Então, isso é muito triste para nós, que temos isso de muitas gerações e hoje isso está se perdendo.
Como diz a boa fala da Marajoara, a gente amarga aí, jogando rede, puxando rede e não mata nem para comer. Às vezes, tem vezes que a gente traz nem um peixe para comer de fora.
Quando os barcos quando os pescadores estão aí fora, quando a gente diz fazendo sua pesca, os navios vêm e eles vêm praticamente em cima dos pescadores. Então eles que têm que desviar, correndo até o risco de que o navio possa passar por cima dos barquinhos deles.
Olha, quando o navio passa aí no canal aí, pega a rede do pescador nosso aí, ó. Tem só o cabo, ó. Só o cabo. Fora o pano leva tudinho, ó. Prejuizão, olha, que a gente tem, ó.
A gente reda, o navio passa por cima da rede, no meio da rede.
Cada vez tá ficando mais difícil. Eu não sei daqui o futuro dos meus netos, dos meus filhos, que vai ser aqui para frente. Porque o jeito que tá ruim.
É muito triste para mim, porque eu que tenho filhos, hoje, daqui a 10 anos ou 15 anos, posso dizer que ele não tenha mais essa realidade que eu tive, que a minha família tem.
É muito triste para a gente saber, né, que a gente pode perder a nossa riqueza.
Quem deu o direito de leiloar os blocos no mar? E com o aumento dos grandes navios petroleiros, há riscos de um extremo colapso na região do Marajó, de um extremo colapso dos ecossistemas marinhos na bacia amazônica.
Nosso território, que é um paraíso, uma coisa ótima, linda para nós viver, vai ser impactado e vai continuar sendo impactado por eles, e mais ainda se vierem para o lado daqui perfurar. Então, vai prejudicar total a nossa pescaria, nosso modo de vida, nosso território que era para caranguejeiro, camaroeiro, pescador, vai ser totalmente impactado.
Somos nós que preservamos a floresta, somos nós que fazemos o manejo da pesca.
Ninguém, nenhum representante de nenhuma empresa veio aqui conversar com nós.
Fazem, vêm, furam, poluem, a gente fica à mercê disso.
Nós queremos lutar por isso, para que alguma atitude seja tomada, para que essa situação não venha continuar e que, de alguma forma, esse pescado ele possa voltar, para que as famílias não sintam mais essa necessidade que está tendo agora, com essa escassez, com essa falta.
Então esse é o momento da gente dizer, olha, nós estamos aqui no nosso território pesqueiro, no município de Salvaterra, na ilha de Marajó. Nós não queremos viver com óleo nas nossas praias. Então a hora é de nos chamarem para a gente construir essa transição energética juntos. Governo, sociedade, território, povos da Amazônia. E o Estado brasileiro, ele precisa ter uma posição com relação a isso.
Thank you very much for letting us show this video, Madam President. Nelson, thank you very much for being here in this tribunal. Thank you for coming here from so far away. And thank you for allowing us to hear your voice. First, we would like to know who you are and why do you know the territory of which you will speak of. With your permission to speak in my own language, thank you. Good morning to the tribunal. Thank you very much for receiving our claims, our denunciations. I am Nelson Bastos. I am a fisherman from since I was 12 years of age. I consider that my great-grandfather and my grandfather and my great-grandfather and my father and my mother, they always lived in this territory that we are fighting to defend. We know, Mr. Nelson, that besides a fisherman, you have a doctorate. What is your doctorate in? We live in the wonderful... For many decades, we lived there in our territory, but we didn't know why we were silenced in this way. So I want, after my 40 years of age, I have a doctorate by the Federal University of Pará in sustainable movements and family agriculture. You mentioned in the video that before this threat existed, oil threat existed, in the territory there was abundance, was the word that people used in the film. What is abundance? This abundance means for us a lot of shrimp, a lot of fish, a lot of siri, a lot of varieties and species of animals. This abundance means harmony with forests, with water, and with our sacred spirits that protect our lands. So this is the abundance we speak of. When the territorial, when the land is not threatened, we lived in harmony and abundance. And when we realize of a threat, then we have this abundance ends, as you were able to see in the video. What does it mean to fish for your culture? Fishery for our culture is our life, because it's the fishing. From fishing we get our resistance when faced with the challenges of the sea. And the sea, we learn to face challenges, and so fishing for us represents the motive to gives us motivation to live fighting, and each fish that dies for us is part of us. A part of us also dies, and that is why we will defend our territory, which is part of us, with our life if necessary. This abundance and this practice of fishery was lost. Why was it lost? We realized that in 2023, 2022, starting with the tests of seismic tests, lots of tons, we have found tons of fish dead in the beaches, but the company did not notify this. It was general sadness that filled us. In the Foss of Amazonas, we are 500 kilometers away. The Isle of Marajó is in the basin of the Amazon. So in this moment, this abundance stopped, did not exist anymore. Now we're suffering the lack of fish in our territory. You mentioned the word collapse was mentioned. So not only for the peoples and the fishing communities now, but for the future. So why is there a collapse now? Because our forefathers gave us a territory with a lot of abundance. with a lot of nature, alive nature. And nowadays, we are seeing how these great projects that are coming to our Amazon basin have a risk of synthetic liquid spills that come with perforations, and this we can foresee a reduction, and we're going to have pollution. I can assert also that we, with our fishing, we are with this, when there is collapse that is coming, when we start understanding this, all our mangrove, all the life that exists in the mangrove and the ports and the rocks that we have in this region, our Amazon corals, when oil comes, all of life ends for us. In the Brazilian state, did they consult you, or the information that you've gotten, has it been, is it in some official record? No. It, there was no consultation. What happened in reality were that there were informative meetings where the communities, where the fishermen could not participate. They didn't have a voice. It was just to listen to the technicians. And when they questioned or when they closed the meeting, they would close the doors to the meeting. I ask that in this tribunal to declare the basin of the Maranhão, of the Marajó and the Amazonas River as an exclusion zone, and that our territories be declared free of fossil fuels. Thank you very much, Nelson. I would like to call Madam President to a brief testimony that will allow us to conclude this issue. I would like to have Rodrigo Leitao come to the stand, please.
Rodrigo, buenos días. Gracias por estar en...
Rodrigo, good morning. Thank you for speaking to the tribunal. Could you tell us who you are and why you can contribute to this case? I am a lawyer. I am a lawyer of the indigenous peoples of... How long have you worked with Quilombeiro peoples and indigenous peoples in the zone? I have been working with traditional peoples of the Amazon for more than 15 years. We would just like to ask of you, after what we've heard and what we've seen in the video, could you tell us from your perception and your knowledge what are the consequences for bio-socioeconomy of the communities of this? This project is a project of death. It's a project of that damages the dignity of people and damages the perspective of dignity of future generations. Rodrigo, what would you ask from this tribunal? I want to speak in Portuguese, with your apologies, so to ask the request. I ask this tribunal that they recognize the rights that are denied by the Brazilian state to the indigenous peoples of Ayapoque, to the artisanal fishermen of the coast of the Amazon. I ask them, as the tribunal, that you react firmly, and I extend the invitation of this presidency so that they can come to the territorial and visit the Ayapoque, that they come to the Marajó Island, and you learn what is the biosocioeconomy of this region that sustains generations and can sustain more generations. It is an instrument of struggle against the climate crisis. It is an instrument of fight against the humanitarian crisis that we're living today. And it is something that generates, and it is an economy that is being destroyed and turned off by the Brazilian state. Thank you very much, Rodrigo. Thank you, Ramiro. Madam President, We would ask to the stand the final expert, which is João Pedro Galvão.
Hay una imagen que quisiera proyectar.
There's an image that they wish to project on the screen, if possible. João Pedro, good morning. Thank you very much for being in this tribunal. We would ask you to introduce yourself and tell us why you can contribute to this case. Good morning to everyone, to the judges, to the president. My name is João Pedro Ramayo. I come from the Coastal Marine Amazon. I'm director of the collective that supports the indigenous peoples who are ambassadors of the Marañón, and I also investigate sustainable development in the humid tropics, and I also consider and I am and have studied ecology and issues of Amazon. With this knowledge of as an ecologist and the experience that you have, can you tell us a little bit about how the state has conceived the project in a fragmentary form? Yes, Mr. Prosecutor, for this I would ask the judges and the public to look at the map and the screen. Since they told me that I could have 3 months to I prepared a presentation so I can tell you everything. I swear I put the watch on. So, excellent, Your Excellencies, I would like to ask you to look at the map. The point in yellow, or way up, furthest up, is what is called the Morpho well, block 59. If we look simply at this point, it could seem that we are in an isolated intervention of a distant point that is 175 kilometers from the coast, so it doesn't generate concern. But now I ask you that we move our sight away from the yellow point and we observe the whole map. What appears is something much different. What we have in reality is that block 59 that we were dealing with today is the concrete manifestation of a much broader oil frontier. All those points that you see over there, that is advancing over the Amazon mouth, and it goes through the Atlantic coast of the Amazon towards the Foz Amazonas, the Pará Marañón, and another basin. So these are 3 segmentary basins, although now we're talking about block 59, which is in the first one. And here we see a fundamental contradiction. The oil expansion fragments that which nature maintains connected. So it's good to tell you that now we have the license of investigation of Block 59, but around this block there are 4 others that Petrobras has license to, and that its presidency 2 days ago, after they announced that they have discovered oil, that they were going to use the same process of Block 59 for the other 4 blocks around that the oil companies already have. And last year in June, before the license of research, they had already assigned other 19 oil blocks. This proves that what we're dealing with now is not an isolated case of Block 59. It's a systemic advance of a whole frontier that has 3 basins and their interconnectivity. And Petrobras, what they do with the permission of the state, it infringes upon. It has the blocks by separately. They license the wells individually, and each company should present individually their own structure of support: ports, airports, ships, roads, and other logistics infrastructure. Now I talked about the block of Petrobras, but Chevron, ExxonMobil, and Total Energy already have assigned blocks that are going to require other individual processes. If we look also ecologically at this, and not a fragmentary way, what would be the potential damages that that yellow point and all of those red dots could produce systemically, ecosystemically, in all of the subjective rights that we are talking about? It's good to say that in the international spaces, our best science has tell us that we lack research, we lack investigation. In this map itself, you're going to see a slightly pinkish color. This is the system of reefs of the Amazon Atlantic. So there's a system of reefs that does not respect the separation of segmentary basins. This system of reefs goes through the Foz Amazonas basin, through the Paramariñao and the Bajeriñas basin. And the scientists from throughout the world, the greatest specialists, already told us that they need only 30% of this reef has been researched. There's not even information. At the same time, you cannot see it in this map, but we have the Amazon plume, which is made up from the sediments that come out of the mouth of the Amazon. So everything that comes from Peru all the way to the Atlantic arrives into the here and creates a plume that distributes phytoplankton and sediments, and it is connected by all the marine coastal flows. And also, besides this, we have the indigenous people. We have the fishermen from Maranhão. The investigation of a doctorate approved by Brazilian government confirms that the fishing territories include this, that this territory, indigenous territory of the Ipoque indigenous people of this territory, goes until Cabo Range, the national park of Cabo Range, which could be impacted by an oil spill like it happened already in January this year, where 18,000 liters of oil were spilled in the ocean.
The last question, very briefly, what are you asking from this tribunal? Three things. First, that this tribunal may recognize that there is a coastal marine Amazon that is needs to be identified in this map, and the Brazilian state must recognize the coastal marine Amazon as a subject of rights throughout its interconnectivity. Second of all, for the Brazilian state to have a responsibility with the corporations and to carry out the synergic studies of the impacts, not to allow the fragmentation of the concession of blocks, licensing of wells, and also the infrastructure that supports it. And also to produce, as the lawyer said, an assessment of how much these territories produce in these coastal marine areas. Because they propose oil as an energy alternative when Brazil has an energy mix that is quite diverse. They generate the profit, but when actually these territories already produce wealth and profits to the Pará state and Brazil in such a way that the state is not accounting for. Thank you, Pedro. Madam President, we have finished with these evidence, and I would like to make some comments and closing arguments and request for this case. Previously, do we have any questions, though? Before that? To questions for the witnesses? Block 59 is 175 kilometers from Oiapoque, and 500 kilometers. There's a difference, a very considerable difference, and the public ministry has submitted an accusation, and the public ministry has filed an accusation requesting the prohibition of exploiting this block of this area. And also the public ministry has requested since March of 2025, they requested the prohibition of this activity. So I ask you something: how can actually this can actually match with the public ministry's request that is not really doing something? I think that to incorporate this last participation made by Joao, to think about adding this type of to this report the trajectory of the public ministry. Just to show you something, I'll give you the floor in a minute. The difference between what you call the Amazonian coast, they call it equatorial margin coast that goes from the Oyapoque down to another river, which is the biggest mangrove in the world. These are reefs, and I ask you, how are you working with these public ministry actions? Well, this is a very important question. Thank you for asking. Actually, this is what we are doing in the judgment, in the accusation, actually, in our testimonies. We are working on what is no longer there, what belongs to Mother Earth and other arguments of the rights of nature. But we are working closely with the prosecutor, with the Federal Republic, Dr. Rafael, that I would like to greet, so that we can think about how to integrate this view of the rights of nature in a broader case. And we have Pan-Amazonian organizations here. That's why we call it the Pan-Amazonian Social Forum, because the equatorial view of things confuses things, because we forget that there is an Amazon that is mega biodiverse and it's coastal and marine at the same time. They don't take it into account, but it has to appear in Pan-Amazonian fora as a subject. Although we are coordinating this into the equatorial margin as a subject, which I think is a great idea. Thank you so much, Judge, and thank you, Joao Pedro. Any other questions? Yes. The vessels that appear here, they are iron, not oil. These vessels that appear in the video, and I request those who worked on the video, these are vessels that are shipping iron. They leave the Punta Arena port in Itaqui, and the airport, the big airport, is the military base of Alcántara. Apologies. With all due respect, is not the Oyapoc. The Alcántara base is a huge airport to launch rockets and missiles, and this is part of the Trump plan. Trump signed a letter with Javier Bolsonaro. Apologies, Madam President, if I'm extending myself in this question. However, when Jair Bolsonaro signed a letter with Donald Trump stating that they are signing a technological safeguard agreement, everything that Trump controls. Look how interesting he's controlling and monitoring the airspace. This is scary to have this as a principle, but we need to include it in our analysis. I would like to congratulate you. Very well presented, but we need to have more efficiency, and also to protect the image of the federal public ministry. From the beginning, they are insisting on this. Right, Rodrigo? The public ministry is insisting, and I haven't seen a reference to the actions of the public ministry. We need to discuss this. I'm quite in favor of discussing this for a long time. Alfredo, the public ministry has conducted excellent work. There is an area that serves traditional people at the public ministry, and they have been acting firmly in the Brazilian Amazon region, not only with Block 59, but also illegal mining, the landslides and floods. We are in dialogue with the public ministry. We want to build an instrument for the struggles that can be quite efficient within the legal framework of Brazil. And I think this requires to be safeguarded and to have a robust evidence. And for this, we need to have a very strong decision by this tribunal that can generate instruments so that we can actually file an accusation and litigate and to carry this accusation to international levels. I would like to thank Dr. Rafael and the Public Ministry of Pará that defends these populations. Thank you. I'm also going to add and hand out a dossier, a report that has to do with the actions of the public ministry. Within the government, there is a contradiction, and this is part of the government. This is a fight that you are carrying out, and I think you are doing very good work highlighting the work of the public ministry. Thank you. Thank you, Presidents of the jury. Thank you, Rodrigo. We now would like to present the closing arguments, President of the jury, in three parts. First, we would like to refer to the sources of law that this tribunal must take into consideration, and in all cases, very likely. Second, referring to the violations that we have heard from the Universal Declaration on Mother Earth. And first, the sources of law. The Inter-American Human Rights Court in the year 2025 issued a consultative opinion on the climate emergency and human rights. And I want to highlight two things about this opinion. First, it recognizes that the rights of Mother Earth, the rights of nature, are part of an evolutionary process of human rights, and they can be argued in all states, member states. And this is one first point that refers to the evolution of rights and the impact of this tribunal and the rights of nature. Second, I would like to highlight that the Inter-American Human Rights Court states that to fight climate change and the climate emergency that destroys ecosystems, that refers to pollution and climate change, the people, we have the right for the best scientific knowledge to be able to address climate change, and that we must consider that the knowledge of indigenous peoples are scientific knowledge. That means members of the tribunal that here the people appearing here are not only witnesses, they are experts. The knowledge of indigenous peoples are as scientific as the scientists appearing in this tribunal. We would like to consider these as a source of the rights of nature, to invoke these to develop the contents of these rights. The second thing that I would like to express is the violations that have taken place to the Universal Declaration of Mother Earth. And I would like to start with the norm that establishes that Mother Earth has the right to be unique and indivisible. We have seen here how an oil project fragments nature. At the origin, we had 237 offers or bids for oil wells.
2019, 47 se ofertaron. De esos, 19 se adjudicaron y de esos, 1 están explorando. Quiero que vean la dimensión de esto. Se están hablando, como vimos en el mapa, 237, 19, 47. Esto, para el Estado brasileño, son cuadraditos, son puntos en un mapa. Cuando para la gente es el territorio, para la gente es el mar, para la gente es el ecosistema, para la gente es completo, no un cuadrado y no un punto. Por esto se viola el derecho a que la naturaleza sea considerado única e indivisible. El segundo derecho tiene que ver con la identidad. Nosotros estamos hablando acá de la costa marina amazónica, que incluye arrecifes, cangrejos, camarones, peces, miles de millones de peces de distintas variedades, bosques, pueblos indígenas, selva, árboles, ríos, lagunas. Esto es la naturaleza. ¿Qué es este proyecto para el Estado brasileño? Bloque 59. Se está vulnerando la identidad de los derechos de la naturaleza y de la costa marina atlántica. Esto no es un bloque 59. Esto se llama sujeto ecosistema atlántico marino. Se violó el derecho a la identidad. El derecho a la integridad física del ecosistema. Para el Estado brasileño, el bloque 59 y todas estas concesiones son un aeropuerto, un puerto, barcos, una plataforma que se construye en la mitad del mar, que es como si que fuera el mar un cuerpo, es como si nos incrustaran un clavo en la mano. Y esto es una violación flagrante al derecho a la integridad. Construir una plataforma es herir al mar, es herir al Atlántico. Y esto es una vulneración flagrante, clarísima y grave a la integridad física del océano y de la costa marina amazónica. El otro derecho que se vulnera es el derecho a que este ecosistema de la costa marina amazónica cumpla su rol, como dice la Declaración Universal de la Madre Tierra. Y cumplir su rol es que cumpla sus funciones ecosistémicas. ¿Qué hace? Aquí hemos escuchado a nuestros compañeros indígenas de Oyapoque, hemos escuchado a un pescador, hemos visto un video y sabemos que el ecosistema está con profundas relaciones, no solamente entre los humanos con los ríos, las aguas y la selva, sino también con los espíritus. ¿Y para qué? ¿Y qué es? ¿Qué es este ecosistema para el Estado brasileño? Petróleo. Al considerar todo ecosistema, este ecosistema del Estado brasileño como solo petróleo, está impidiendo que el ecosistema cumpla todas sus funciones físicas, materiales y espirituales con los pueblos indígenas. Con todo esto, señora presidenta, señores miembros del tribunal, queremos decir y pedir, primero, que se declare a la costa marina atlántica como un sujeto de derecho integral y ecosistémico. Segundo, que se declare la violación a los derechos a la identidad, a la integridad, a cumplir su rol y a estar libre de contaminación a este sujeto de derechos, y para ello que se declare zona de exclusión petrolera también este ecosistema junto con toda la Amazonía. Segundo, exhortamos al Ministerio Público de Brasil para que tome acciones de protección basados en argumentos de derechos de la naturaleza y proteja efectivamente ese ecosistema. Agradecemos la presencia de Rafael, que es del Ministerio Público, y esa sensibilidad para intentar hacer algo efectivo en la zona. Tercero, disponer medidas de precaución para detener la exploración del bloque 59 y que se detenga todas las concesiones que se han hecho en los 19 restantes bloques. Solicitamos al Estado que solicite este tribunal, que pida al Estado que complete su información sobre el informe de impacto ambiental y cuantifique y cualifique los daños en la vida de la gente, como lo que nos mencionó los pescadores, y también que se valore cuánto se produce para que se rompa esa farsa de que explotar petróleo es desarrollo y progreso. El desarrollo lo tienen sin petróleo esos pueblos. Segundo, pedimos que este tribunal acompañe y visite in situ la zona donde se está explorando el petróleo y se vea la forma de vida que se está alterando y se está perdiendo. Finalmente, pedimos que se tomen todas las medidas que se consideren necesarias para que se restaure integralmente el ecosistema marino atlántico. Muchísimas gracias.
Muchísimas gracias a los dos fiscales de la tierra para el presente caso, el doctor Ramiro Vélez Santamaría y la doctora Fátima Monasterio. A continuación, y antes de poder escuchar al alegato final del fiscal doctor Mario Melo, vamos a escuchar al experto de la Universidad de Padova, Massimo Di Marchi, sobre consideraciones finales técnicas y el mapeo de la explotación petrolera en la Amazonía. Muchísimas gracias, Máximo, para que los jueces puedan tener más elementos a considerar para su veredicto.
Gracias, Natalia, gracias a todos. Le pido si puede partir con la presentación. Mi reflexión es sobre el tema del papel del mapeo como herramienta de cambio y como herramienta que ayuda a visibilizar cosas que al momento a veces no pueden ser visibles. Vamos a la primera slide. Este es una imagen terrible. Cuando usted visita el Museo del Apartheid de Johannesburg, hay esta foto llamada Los Arquitectos del Apartheid. Quiere decir, la apartheid fue planteada también en el suelo, dibujando barrios donde vivían las personas de color y barrios donde vivían los blancos. Los lugares de las personas de color que iban a trabajar en las ciudades debían ser lejos, ser complicados de llegar, tomar mucho tiempo para usar los transportes, y el resultado es que después del apartheid, Johannesburg es una ciudad llena de áreas verdes y parques, porque son el resultado de la separación entre la área productiva y la área de vida. Este fue planteado. Vamos a ver la próxima. Y aquí vamos a ver cómo se está planteando, como nuevos arquitectos del apartheid están planteando la separación de este maritorio entre costa y Amazonía. Vamos. Hay toda una producción de mapas oficialistas. La próxima de nuevo. Que son mapas lindas donde parece que todo está simple. Aquí usted puede ver cómo está planteado todo el tema de la extracción petrolera, ¿no? Parece que solamente hay un recorrido de barcos, todo está bonito, con colores bonitos. Este es el mapa que va a contar cómo el proyecto toma cuenta de los posibles impactos petroleros. Y es una narración edulcorada de una realidad que está totalmente lejos de lo que puede acontecer. Vamos a la próxima. Aquí los mapas enfocan todo el caso de los municipios que puede ser afectado por la actividad petrolera. Vamos a la próxima. Esta es siempre esta imagen que dice, sí, mira, todo es una historia de mar. Hay una plataforma en el mar, hay solamente dos lugares donde llegan los barcos en Belén, donde salen los aviones de Oiapoques, pero hay toda una cosa y el impacto es solamente en este corredor gris, ¿no? Es curioso cómo se juega en la colocación del corredor y de las áreas de sensibilidad. La próxima. Ahora, aquí hay un elemento interesante, es casi una producción de territorio esquizofrénico. El estudio de impacto ambiental mira solamente a la parte de la costa brasileña. El estudio de dispersión de óleo en caso de contaminación analiza la costa desde Oiapoque hasta las islas de Caribe, Granadine, etc. Y son 1.500 kilómetros. Okay. Vamos a ver a la próxima. Hay una declaración que dice al final que no hay impactos de petróleo en caso de vazamiento en la costa brasileña. Solamente podría tener impactos en Santa Lucía, San Vicente, Granadine, Barbados y Trinidad y Tobago. Quiere decir, brasileños no se preocupan porque en caso de derrame los impactos van a ser en el Caribe. ¿Okay? Próxima slide. Ahora, la cosa interesante es que entre los primeros estudios de 2015 y los más recientes de 2019, a un cierto punto desaparecen las islas del Caribe. Puede volver atrás de 2 slides. Mira, aquí hay una representación, se ve la isla del Caribe. Próxima slide, la isla del Caribe próxima desaparece y el estudio de impacto ambiental más reciente nunca enfrenta de nuevo este asunto. Vamos a la próxima. Entonces, tenemos una costa amazónica que no es solamente la costa brasileña, ma incluye también la Guyana francesa, la Guyana y Suriname, y una costa que tiene una realidad que llega hasta el Caribe. Son 1.500 kilómetros, no hay estudio de impacto ambiental sobre este asunto, el estudio de impacto ambiental analiza solo la dimensión de Brasil, pero el estudio de derrame analiza la costa arriba y no analiza la costa en abajo, porque dice no hay problema porque los vientos y la corrienteza van en esta dirección. Entonces aquí hay una profunda contradicción y un problema legal extremadamente grande. Hay impactos que salen del territorio brasileño y desafortunadamente en el contexto latinoamericano no hay una regulación para los impactos ambientales transfronterizos que hay, por ejemplo, en el sistema UNECE. Si yo en Italia hago un estudio de impacto ambiental y puedo tener impacto en Suiza o en Austria, tengo que hacer una evaluación de impacto ambiental transfronterizas. Aquí en el sistema de regulaciones ambientales de América Latina falta este elemento, es un elemento extremadamente grave porque el tema no es reducido a la costa y a la salida del río Amazonas porque la pluma de sedimentos llega hasta Guyana, es mucho más grande, ¿no? Entonces este es un primer aspecto. El otro aspecto, tenemos que manejar este asunto utilizando la declaración de Río. Más adelante, ahora, este es el mapa que hemos producido como grupo de investigación, lo está haciendo Daniele Vezzelli, que está terminando su doctorado haciendo un caso de estudio sobre la explotación de petróleo en Brasil. Va a la próxima slide. Este es impresionante porque todo el tema de la costa brasileña empieza en la área amazónica y llega hasta el sur, con Uruguay y más abajo. Y aquí hay un análisis de cómo toda la actividad petrolera de Brasil está poniendo críticos elementos a lo que son los activos naturales críticos, es decir, todos los recursos naturales que sirven porque la gente haga una buena calidad de vida. Yo no sé, pienso de que he terminado mi tiempo. Un minuto. Ok, próxima slide, próxima, vamos hasta la final. Este es un estudio que hemos hecho sobre Ártico, pero vamos a la slide final. Próxima. Este es el caso de Amazonia, adelante. Aquí, se para aquí. Este es un único caso de análisis ambiental donde hemos evaluado cuál es el impacto de la actividad petrolera sobre otros sectores económicos, porque siempre el petróleo parece la única solución económica en un lugar. Okay. Este es el caso de Italia, donde tenemos el bloque Eni en el sur de Italia, que es uno de los más grandes bloques continentales europeos. Okay. Este bloque está dentro de un parque natural y la compañía dice que ellos existían antes del parque, ¿ok? Y la cosa que calculamos es, esta es una área donde hay una grande producción de alimentos de calidad, quesos, vinos, etc. Entonces, hemos calculado cuál es el depreciamiento de valor de la producción alimentar típica en caso de petróleo. Muchas gracias.
Muchísimas gracias al doctor Máximo De Marchi por esa presentación. Quiero anunciar que la Secretaría del Tribunal Internacional de Derechos de la Naturaleza se mantiene abierta, por lo tanto, esta información que nos acaba de presentar Máximo De Marchi, como cualquier información que los testigos quieran seguir entregando a la Fiscalía, podrá seguir abierta mientras se desarrolla la conclusión del veredicto. Por lo tanto, anunciarles que la Secretaría está abierta para recibir sus conclusiones. Y mientras invitamos a Mario Melo para que el doctor Mario Melo pueda entregar su alegato final, solamente comentarles que desde la Secretaría Internacional de Derechos de la Naturaleza del Tribunal se hizo entrega de las cartas para invitar a todos los responsables que fueron identificados por los testigos en Santa Marta. De estas cartas, y para que lo tome en cuenta el fiscal y los jueces, de estas cartas la Secretaría recibió respuesta de IBAMA, Petrobras Brasil, Petrobras Bolivia y el despacho presidencial de la recepción de Colombia el 5 de agosto, solamente recibiendo el documento. Principalmente las respuestas de IBAMA, Petrobras Brasil y Petrobras Bolivia fueron respuestas bastante vagas, que solamente plantearon que si ellos hicieron las evaluaciones de impacto ambiental según los más altos estándares y consultaron a las comunidades afectadas. Sin embargo, esa información se contrasta fuertemente con las evidencias entregadas a ese tribunal. Sin embargo, la respuesta a este tribunal reconoce la competencia y autoridad del mismo por las instituciones que respondieron al mismo. Con estas presentaciones también de la Secretaría, para que se tomen en consideración por el alegato final y por los jueces, queremos dejar planteado que todas las instituciones responsables fueron notificadas del presente tribunal. Adelante entonces al doctor Mario Melo para que pueda dar su alegato final de estos 6 casos que hemos escuchado esta mañana.
Señoras jueces y señores jueces del Tribunal Internacional de Derechos de la Naturaleza, voy a recoger algunos puntos en común de los casos que se nos ha compartido la mañana de hoy. La primera conclusión común es que la actividad hidrocarburífera tiene efectos catastróficos para la madre tierra y para sus ecosistemas. Hemos escuchado relatos sobre contaminación de la selva, de las aguas dulces, del mar, de los animales, del aire, del suelo. Los efectos que tiene la industria hidrocarburífera son de una escala y de una profundidad que debe hacernos pensar profundamente como humanidad si es que el camino de nuestra sobrevivencia sigue siendo la explotación de los recursos del subsuelo. La segunda conclusión que pongo sobre la mesa es que la experiencia petrolera de las comunidades afectadas es una experiencia de pérdida de territorio, de pérdida de medios de vida, de ruptura de sus tejidos sociales, de fractura de la armonía comunitaria y la armonía familiar. Eso es algo en común en los relatos que nos han hecho las testigas y los testigos a lo largo de toda la mañana. En ese contexto, la experiencia petrolera en relación a los defensores y defensoras de la naturaleza es que se convierten en personas perseguidas, criminalizadas. Se atenta contra su vida, su integridad, se les encarcela, se les enjuicia y se les encarcela y se limita su libertad de expresión. Entonces, la actividad petrolera no afecta solamente a la madre tierra, afecta también a las personas o los seres humanos que formamos parte de la comunidad de vida. Y se ensaña además especialmente con aquellas personas que hacen de su actividad la defensa de los derechos de los otros. Entonces, también hay que tomar en cuenta estos factores para ver en su transeccionalidad y en su complejidad el fenómeno de la actividad petrolera en territorios indígenas y campesinos. El siguiente elemento que quiero destacar es la profunda dimensión espiritual que tiene las afectaciones a los territorios por parte de la industria petrolera. Hemos escuchado de la especial relación de carácter espiritual que tienen las comunidades con su territorio y cómo esa relación se ve fracturada, amenazada, lastimada por las actividades extractivas que se realizan. Nos han hablado de la sangre de la tierra, nos han hablado de los seres especiales que habitan en los bosques, nos han hablado del dolor de la madre tierra, del ser consciente y vivo que constituye para las comunidades en su cosmovisión la selva, los espacios naturales. Debo también señalar la subordinación general de los derechos y de los intereses de las comunidades locales frente a los apetitos petroleros. Se ve como una constante. que los derechos conquistados por las luchas sociales a lo largo de los siglos se ven subordinados frente al interés meramente crematístico de la industria petrolera. Incluso intereses legítimos como pueden ser el interés de conservación que muestra los estados a través de políticas públicas como son las áreas naturales protegidas, tienen que ceder frente al interés de la industria petrolera. Hay además un incumplimiento permanente y sistemático del derecho a la consulta libre, previa e informada y al consentimiento de las comunidades y pueblos. Eso también es un patrón general que hemos podido identificar. El derecho a la consulta libre, previa e informada que ha sido desarrollado por las jurisprudencias nacionales de nuestros países e internacionales es ignorado, violentado sistemáticamente, como que el modelo extractivista trae de por sí el criterio de que las comunidades no deben conocer plenamente las amenazas que se ciernen sobre sus territorios, que no hay que informarles, que no hay que consultarles, mucho menos pedirle permiso para ingresar a sus territorios y hacer destrozos como son los que hacen las actividades petroleras. Hay también un esfuerzo destacable que en ejercicio de su dignidad hacen las comunidades locales por exigir sus derechos en diferentes espacios nacionales e internacionales. Han habido sentencias importantes, como el caso de los UBA, en los cuales se puede establecer una vez más que los estados de la región violentan el derecho a la consulta, en donde tras luchas que son a veces de varias décadas, se puede establecer a través de los más altos tribunales de justicia internacional que los estados violan los derechos humanos y los violan en diferentes dimensiones, donde se evidencia la ruptura de los tejidos sociales y se evidencia también la pérdida de la identidad cultural de los pueblos vinculado con las afectaciones de la naturaleza. Y también hay que decirlo, que estas sentencias, siendo importantes y siendo victorias destacadas que detienen la avalancha extractivista, no son cumplidas plenamente y oportunamente por los estados. Entonces, con estos elementos que son comunes, la Fiscalía de la Tierra solicita al Tribunal de los Derechos de la Naturaleza lo siguiente. En el caso de Ecuador, en el que hemos discutido y analizado las políticas de ampliación de las fronteras petroleras en los territorios indígenas del centro-sur de la Amazonía, consideramos que dichos anuncios de nuevas rondas petroleras constituyen una amenaza grave e inminente que se cierne sobre los derechos de la naturaleza y los derechos de los pueblos indígenas. Por lo tanto, la Fiscalía solicita al Tribunal que emita medidas cautelares, recordando, insistiendo, exhortando al Estado ecuatoriano de no realizar ningún proyecto petrolero en el centro-sur de la Amazonía si no cuenta con el consentimiento libre, previo, informado de las comunidades que van a ser afectadas, además obtenido de acuerdo a los estándares internacionales de derechos humanos. Y además, si es que no demuestra que cualquier actividad que se realiza no va a perjudicar los derechos de la naturaleza. En el caso de Perú, hemos analizado el bloque 64. En ese caso, este tribunal ya se pronunció y su sentencia ha sido desacatada, desoída, ignorada. Pide esta Fiscalía de la Naturaleza que el tribunal renove la sentencia respecto a este caso y que renove además los esfuerzos porque conozca el Estado peruano en sus diferentes instituciones que este pronunciamiento de la sociedad civil, cargado además de los argumentos que ha presentado los testigos, tiene que ser escuchado, tiene que ser respetado. Además, hemos conocido que están en curso acciones ante la Comisión Interamericana de Derechos Humanos por parte de las víctimas en este caso. Pide la Fiscalía de la Tierra que la sentencia sea remitida a la Comisión Interamericana de Derechos Humanos en calidad de amicus curiae, para fortalecer la defensa que estos pueblos están realizando en ese organismo internacional. Respecto a Colombia, hemos escuchado el testimonio y la presencia de los hermanos UWA, que nos han relatado su lucha, sus sufrimientos, la persecución de la que han sido víctimas y además el haber alcanzado una victoria judicial ante la Corte Interamericana de Derechos Humanos. Y nos han dicho también que si bien esta victoria es importante, es histórica para los pueblos de las Américas, la sentencia no está siendo cumplida. Entonces, la Fiscalía de la Tierra pide al Tribunal Internacional de los Derechos de la Naturaleza que acuda ante la Corte Interamericana, que está haciendo seguimiento del cumplimiento de su sentencia, y le haga conocer que el caso también ha sido conocido en este tribunal y que hay recomendaciones para que la Corte haga conocer al Estado colombiano una vez más su obligación de cumplir plenamente con los compromisos internacionales frente al sistema interamericano, y le haga conocer que este tribunal también va a hacer seguimiento de ese cumplimiento. En el caso de Venezuela, hemos escuchado la aterradora historia de una zona de sacrificio, de una zona donde, al decir de los testigos, la contaminación brutal y las afectaciones a la vida y a la integridad de la naturaleza y de las comunidades de pescadores se han normalizado, como que fuera normal el que la gente sufra y que la naturaleza sufra. En este caso, la Fiscalía de este tribunal, la Fiscalía de la Tierra, solicita que el tribunal condene al Estado venezolano por haber violado la Declaración de los Derechos de la Madre Tierra y además condene por la violación de los derechos a la integridad, a la vida digna de las personas que viven del mar y que ahora no tienen sus medios de vida debido a la contaminación de la cual han sido víctimas. En el caso de Bolivia, esta Fiscalía de la Tierra destaca la contradicción profunda que existe entre una política pública que ha considerado valioso un territorio en términos ambientales, o mejor dicho, en términos de ser soporte de vida de comunidades, al haberle declarado área protegida, frente a la política del mismo Estado de, sobre esa área protegida, impulsar proyectos extractivos de petróleo, que como hemos dicho, traerán efectos catastróficos para la naturaleza y para las comunidades. Y hemos escuchado también el testimonio de la persecución cruel que han sufrido las defensoras y defensores de derechos de la naturaleza y derechos de las comunidades. Por esa razón, la Fiscalía de la Tierra pide al Tribunal de los Derechos de la Naturaleza que en su sentencia se condene al Estado boliviano por no haber respetado los derechos de la Madre Tierra que fueron consagrados en una declaración erigida en su propio territorio, y que además ha sido incapaz de cumplir con sus propios compromisos con su pueblo al haber declarado un área nacional, un área protegida, y haberla vulnerado con la política de ampliación de la extracción de petróleo en esa misma área protegida. Además, este tribunal deberá señalar que las defensoras y defensores tienen derecho a ejercer su actividad de defensa, y ese derecho debe ser garantizado por las autoridades bolivianas y por todas las autoridades de la región. Con esta intervención cierro la actuación de la Fiscalía de la Tierra en este caso. Agradezco mucho por la atención que se ha brindado a cada uno de los declarantes y le manifiesto que para mí ha sido un honor haber conversado con cada uno de los declarantes, haber aprendido de sus historias, y les expreso mi total respeto por las luchas que vienen desenvolviendo. Muchas gracias.
Muchísimas gracias al doctor Mario Melo, fiscal de la tierra en este Tribunal de Derechos de la Naturaleza. Muchísimas gracias a nuestros dos fiscales para el caso FOS de Amazonas, el doctor Ramiro Ávila Santamaría y la doctora Fátima Monasterio. Gracias a todos los testigos y testigas que pudieron estar hoy en este tribunal y gracias a todos los jueces y juezas que hoy nos han honrado con su presencia, escuchando con tanta atención estos testimonios tan fuertes. A continuación vamos a salir para el almuerzo. Los jueces van a tener 1:20 para poder deliberar las conclusiones de veredicto oral que se presentarán en la tarde. Los testigos también tendrán un almuerzo, entonces vamos a pedirles que puedan salir con Emi, que les va a estar esperando afuera, y que los jueces se permanezcan en la parte de atrás. Y les solicitamos a todas las personas aquí presentes que volvemos a las 3 de la tarde, en punto, 3 de la tarde aquí, para poder escuchar las sentencias orales de este increíble panel de jueces. Muchísimas gracias. Muy buenas tardes.
Good afternoon, everyone. We're going to restart. Please. We're in the second part of the third regional tribunal of the rights of nature for an Amazon free of fossil fuels. We are restarting the session happening in Puyo, 19th of August of 2026. In this session, we've heard 6 cases from all the Amazon region. After the deliberation of the judges here present, we come back to hear the oral ruling that they have to share with us. Before this ruling or judgment, we want to commemorate that the International Tribunal of Rights of Nature was born for a very fair cause, just cause, which is the most important cause that joins us here in this 12th FOSPA and in this tribunal, which is the cause for Yasuni. The tribunal was born because of Yasuni. Its first audience happened in January 2014 after it was proposed to eliminate the ITT Yasuni proposal. In 2014, 3 local tribunals were heard on Yasuni, and the International Tribunal of the Rights of Nature has heard the case of Yasuni on 5 occasions: in Quito in 2014, in Lima in 2014, in Paris in 2015, in Bonn in 2017. It had a pronouncement in a place when it was decided not only to not exploit the oil, but when Ecuadorians were voting against the exploitation of Yasuni, and it made a statement where, and there the Ecuadorian people decided with a 59% not to exploit Yasuni. So we heard the lecture by Juan Bay Yasuni in 2018, because in 2024 there was already a lack of compliance of this important mandate, citizen mandate, that was the the referendum. To hear about this case now, tomorrow will be the 3rd anniversary of the referendum for Yasuni, and we want to invite a colleague from the Guarani nation to hear about his perception about what has happened in the last 10 years, what we expect from the government, and what we demand of the government for Yasuni.
Yo estoy con mi libro. Wapone gawereke tomaminitono.
Hello, brothers and sisters. How are you? It's a pleasure. My name is Juan Bay. I am president of the Guarani Nation in Ecuador. Thank you, Tribunal, to the judges that are accompanying us. I think it's very important in this public audience to be able to not only tell the story, but share the historic struggle that we have been carrying out as Guarani Nation in Ecuador. It is important to learn get to know the indigenous peoples and to know this history of each people. The Waorani people has only been in contact with civilizations in 50 years. We have been facing for many years defending our territory, our common home. You know that after so much struggle of the indigenous peoples in Ecuador, in 2008, the Constitution recognized the right of nature. This is the first country where they wrote down that nature is a living being, and that as we've mentioned, that this cannot be spoken separately. If the moment we destroy nature, it's like exterminating and killing the indigenous peoples directly. So this is a block. If you threaten indigenous peoples, it's also like threatening nature. And so, brothers and sisters, as you might know, this is the first country that in 2023 carried out a referendum where the indigenous peoples, the Waorani nationality, began with a campaign for the defense of the territory. And we have walked throughout different cities in the country. We have had some communications also so that our brothers and sisters in other places can join to our struggle. So on 20th of August, we celebrate together this victory. And when the world said it is possible to defend the territory, that it is possible to defend the rights of life, and we've also said we've not only defended the Yasuni National Park, we've also guaranteed the life of human beings where we have people living in isolation, the Tagari and Taromenane. And I believe and I feel that starting on 20th of August, the Ecuadorian state had a year to close the well. In that ruling, it is clear that it is not only have to be the close and dismantling. It's been said that they have to close and dismantle and do integral comprehensive reparations to the affected peoples, in this case to the Waorani nation of Ecuador. And after 1 year happened, it went 1 year from 2023 to 2024, the authorities, the state, the government did not have the will. Since then, now started doing actions in its territory, where we had the International Summit for Yasuni here in the city of Puyo, where we joined together many brethren that are leaders of the Amazon basin, NGOs, students, universities, partners, and we created an action plan for the defense of the territory, for the defense of Yasuni. The Waorani nationality presented with the COPCE and to the competent authorities, but still, we've seen that there is no will on the part of the government. Since then, the Waorani nationality began to work on the process with the advocacy internationally. When we were in the Tribunal in New York, we've mentioned and we've said that we need to defend our rights. We've said that the rights are not non-negotiable and we cannot sell. They have to be made respected and kept alive, because if we don't do it now, what else can be done? So, in this process that now has carried out, let's remember that in Ecuador, this is the first country that took an historic case, the Tagari Taromenani case against Ecuador, where the Inter-American Court of Human Rights ratified once and again the immediate closing of the Block 43 within the Yasuni National Park to guarantee the existence and the right to live for peoples in isolation and also with peoples in first contact, the Waoranis. Now, we've also seen the lack of compliance because of lack of will of the authorities of the state. So we feel infringed our right of the indigenous peoples, but we haven't stopped. 60 years have gone by of exploitation and oil exploitation in the Amazon. The authorities and the world has said that destroying Yasuni was development. 60 years have passed, and now the only thing we have left are environmental impacts, changes in our culture, alcoholism, and other problems. And this has signified the death for indigenous peoples. Now we understand and we know that our brothers from the Amazon basin are going through the same struggles. And we have said that if the case in Yasuni is a example globally, if we don't carry out actions together, then what future can we have for the coming generations? Brothers and sisters, before I close, I would like to say that it is very important. I had been looking for a book which is the Feast of Oil, where they start writing about the story of Guaranis. When the Guarani people of back then, the missionaries, the Kuguri, the foreigners, we called us Aucas and savages. Here we are in a resistance. The Guarani people have defended their territory with our javelins, and we are the last nationality. The last killing happened in 2017. You will remember the isolated peoples came and attacked our brothers and sisters, because the isolated peoples have also come out to show that they continue to exist. They need to live in their territory. And I feel in this tribunal it's important to call to reflection our society and to mixed race people and the world regarding the fact that the Amazon includes all of the indigenous peoples. Before calling a state, before calling an Ecuadorian state, the indigenous peoples were here already. We continue to exist, and it's important to mention. And I had to not forget, I wrote down very quickly an advice to give you this message. As I had mentioned, I found that, and I wrote that the oil feast, this book is very important. About in 1970s, they talk about Guarani territories given in concession for oil. In page 45, it says the next thing, and you can find about the stories of how many Guarani had died, how they were murdered by the oil people in these years when the Guarani were still isolated. Since back then, as an anecdote of the terror and fear, they say that in one occasion the army, look what's happened during years in the Ecuadorian Amazon, that nobody tells this about the struggle and throughout the world. So they bombed from the air after the missionaries were attacked by my ancestors, by the Guarani, because they felt that they were being invaded and they wanted to conquer them. So they would call us Aucas before, and the oil people, the foreign actors, killed because they needed to make us run so that we would run away into the jungle because they needed to advance. And like this, they continue to see us until now. The oil companies, extractivists, governments, they continue to call us Indians without rights. And today we have a response clear that indigenous peoples have rights. They have said that we can be threatened, attacked, murdered, polluted in the name of the multinational companies with money over our lives, over the nationality of Ecuador are saying, stop it, enough. We are human beings that have the same rights to live. We have the same right to be in peace in our homes. In closing, for the governments of the Amazon basin, I exhort you to respect our autonomy, our rights, and follow the rulings issued by national and international bodies. a single territory. Thank you very much. Thank you to the room, to the audience also, and very good afternoon.
Muchísimas gracias, querido Juan.
Thank you very much, dear Juan. Thank you for this struggle, for your efforts. And please confirm, Juan, the press conference starts tomorrow at 6 or 7? Please, let's confirm. Okay? My apologies. I don't want to let this slide. I think tomorrow, just like it was said, tomorrow we are having one more year or non-compliance of the referendum. That's why now the Guarani people invite you to make a march, have a press conference, and more action so that from the now we can present to the competent authorities and we're going to raise a legal action. We're working on that. So to all of you who are here, who are visiting us from the Amazon, to our brethren, at 6 a.m. we will start. But if you want to wake up very early, you can wake up in the morning and we can see you at 6 a.m. in the home of the Guarani nation. You are all invited.
Muchas gracias, Juan. Entonces,
thank you very much, Juan. So for the last day of FOSPA, we can wake up very early so that we can accompany the Guaranis at 6 a.m. and then we can continue with our activities of FOSPA at 8:30. So now, in a very long-awaited moment, the oral judgment of the Third Tribunal of the Rights of the Amazon for the freedom from fossil fuels. Firstly, I'm going to call our Judge Mariluz Cañakiri, who is a Cucama Peruvian woman, fighter. And maybe if you can, if the judges, if they could give their judgment, if they could come, that would be good. You can do it from the table if you'd like. Mariluz, go ahead.
Buenas tardes.
Good afternoon, brothers and sisters. It is a pleasure to be here with you. Thank you for coming to listen to us. The great proposal and concern of all of us who have been able to speak here is, I am very thankful. I thank God also for the struggles of my brethren from neighboring countries. We are a single family, big hearts that fights for our mother nature, for our land, for the life of our children and our generations, our coming generations. We fight for a world that we want to have a world of peace, of harmony, nature with harmony, where we understand each other. I would like to ask that all of us get involved for this great work. Many of us have set out to do. I would also like to ask the table that you also consider a request of what Sister Olivia said in the morning. That in my zone, which is the Battery 3 Lot 8X Yanayaku, which belongs to Lot 8, the National Reserve Pakaisaniria in Yanayaku. I would like also that it could also be along the groups of requests and be considered by my population, since we are victims as many others, and that this space should be a space that is really that this goes. We would like that our struggle be acknowledged. Thank you very much to all of you. Thank you very much, Mariluz. So the request was that we can broaden and talk about other blocks in Peru that are being affected in the Peruvian Amazon. It's just here for the understanding of the public. The oral judgments are the response of the judges to what they have heard throughout the morning, including to some of the specific requests of the specific cases. And Gregorio Mirabal, the co-judge, will give the conclusion of the deliberations. So next we will listen to our judge from Ecuador, Alberto Acosta.
¿Cómo hago para subir esto? Muy buenas tardes. Empiezo.
Good afternoon. I begin by greeting the Madam President and Mr. President of the Tribunal, to our colleagues, judges, and to all fellow judges and all the other person here present. I am a privileged person because I've had the luck of accompanying this tribunal from its beginnings. And this has allowed me to learn. I learn in every session. And from what I've learned, I get reflections, and with these reflections, my indignation increases, but I do not lose hope that we need to change the world. It's important that you know that I speak with knowledge. As Jose Marti would have said, if he had worked on oil, I know the entrails of the monster. I know what the oil activity is. I've said it several times. I come from the dark side of the force. I was linked to oil activities in the Ecuadorian State Oil Company. And I thought sometimes for a time that with oil we could reach development. But gradually I have understood that this is a civilization of death. And in this scenario, I think it is very important that we carry out some reflections. The Earth's prosecutor, Dr. Mario Melo, somebody who knows very well this reality and resistances, he's spoken about the threats that can perturb the community of life. And really, these threats are not something hypothetical. This is something real and concrete. In Ecuador, in the Amazon, in the northeast, there's oil activity since the 60s. 60 years in which the country has been trying to reach development by exploiting the oil in the Amazon. And the Amazon, for us, it's our periphery. And so, since August of 1972, so exactly 54 years ago, we began to export oil. Time has gone by, and development is nowhere to be seen. Poverty grows, inequity grows. Some groups still make a business out of the destruction of the Amazon and the exploitation of oil, but this is the reality you must take into account. Oil-producing Amazon is the poorest area of all Ecuador. It's an area with environmental destruction. The destruction of Mother Earth has affected the soil, air, water, and has destroyed whole cultures. In this scenario, we must be very clear about the fact that these affectations to Mother Nature have come to a cost, and they continue to present costs. I could talk very long at length about this very sad story about our country, but I am worried that besides the oil feast, like it was mentioned in the book, is a history. Now they're trying to open the door to mining, and we're starting to see the mining feast. Not only illegal companies, but also legal companies. Legal that in my countries, all of them are illegal because they don't fulfill the constitution. Plus, they have this complicity with the state in organized crime, and this presents a very complex scenario. In our tribunal, what we want to prevent is the crime
of silence, that we don't speak, that we don't say what is happening, because that is what happens from the great media of disinformation. They don't understand that the Amazon was transformed, the Northeast and now the intended Southeast, in a sacrificial zone. And I think that we can recover some of our story and talk about those who will never talk again. When oil activity began more than 60 years ago in the Northeast, two whole peoples disappeared, the Tetes and the Sansawaris, just as so that we can keep it as an intolerable inheritance. These names did not give name to wells, oil wells. It is horrible. Where before we have boys and girls playing, where before we had men and women who loved each other, where before we had grandparents that told stories to their grandchildren, nothing was left. Not a single registry for anthropological registries. Nothing. Absolutely nothing. And in this scenario, I think it's very important to value the resistance of indigenous peoples. All indigenous communities, of one way or another, have resisted to oil activity. We have cases that we could develop longly, like the rebellion of Sarayoku of 1989, where the Amazon peoples joined together to face the oil companies. And Sarayaku continued to fight until they got an historic ruling of the Inter-American Court of Human Rights in 2012. We have other important cases like the indigenous communities and non-indigenous, including colonists, that promote since the year 1993 the historic trial against Texaco and against Chevron, which is something we should not forget. We have taken into account, and also we got this from our colleague from Norway, the ruling that we got in the Inter-American Court of Human Rights for the protection of self-isolating peoples. And of course, I want to remember all the time the contribution of peoples and nationalities of indigenous people for the creation of the Constitution of 2008, where it is recognized for first time and single time in a constitution the rights of Mother Earth, nature as a subject of rights, where we establish mechanisms for the citizen participation, for consultations, environmental, previous free and informed consultation, referendums. But pay much attention. We have to be very careful here and be very cautious when they tell us that we have to wait until it is demonstrated very clearly that oil activity is not going to cause affectations. The Constitution is very clear in Article 73. It talks about the principle of precaution and principle of prevention. But I will tell you, I came from the dark side of the force. With years, I've been learning that oil activity is never going to be sustainable. By definition, it's impossible. It is never going to be responsible with peoples and nationalities, and much less with Mother Earth. To believe that there can be oil activity, great technology that can solve all problems and reduce risks, is like believing that Dracula became a vegetarian and that we can give him the blood bank. So with these scenarios and with all these limitations, recognizing the need to declare the whole of the Amazon, not little isolated pieces, free of fossil fuels, and to declare the whole Amazon as a subject of rights, I think that at least what we have to demand is the fulfillment, at least in Ecuador, of what is established by the Constitution. Article 57.7 establishes previous free and informed consultation for peoples and nationalities. In this article, through what is determined in Article 424, that includes all the treaties of human rights into the constitutional text, opens up the door also to free, previous, and informed consent, including in the ILO Agreement 169. In this context, we also have to demand the compliance of the pre-legislative consultation that hasn't happened in Ecuador. It's a constitutional mandate. Article 57, number 17. There I mentioned the Constitution also establishes environmental consultation for the rest of society. In this context, then, we have to begin analyzing what it means to respect the Amazon without losing sight of its integrality. We've seen in the case of Brazil, for example, the importance of the whole coast of Brazil that is linked to the Amazon. It is a whole. The same are the Andes. The same is the rest of the planet. We need to start looking at Mother Earth integrally in its whole, as a whole, and make sure that we can make valid the rights of nature. And I invite you, I will start finishing up so I don't concern my colleagues, I invite you that we all join the request of support to the public to the referendum of Yasuní. It's 3 years and the struggle continues. We've seen that there's no definitive results, that there are important results that we have to be able to celebrate, but we need to continue fighting. And just as in Ecuador we defend Yasuní, in Ecuador we are also facing mining. I remember the public consultations of El Jirón in Cuenca, in the province of Azuay, and this great struggle of people from the province of Azuay who, in 16 September, configured a fifth river in a city of 4 rivers. The fifth river was the river of people defending water. And in Quito, there was also a popular referendum 3 years ago that prohibits mining in its territory. All of these struggles are very important, but we need to continue delving deeper in this. And with this context, it is important that we continue to start destroying the language that sustains extractivism. Getting in oil industry. It's not the industry that creates the oil, it's the mother nature that creates that. That is a way of raising the level to those who simply destroy nature and destroy communities. That is important too. The prosecutor said it too, that we destroy this discourse that patches up, that splits up territory into blocks. Let's stop talking about blocks. Let's stop talking about lots and about isolated wells. In this sense, let's look at the reality of our Mother Earth, the Pachamama. So our Pachamama, our Mother Earth, for us, mixed race, it's not simply a metaphor. It's a reality, a day-to-day reality for indigenous peoples. And so, picking up the message from the indigenous peoples, we have to make a reality the rights of nature along with human rights, because if we get stuck only in the protection of a pristine jungle by ignoring indigenous peoples, that would be just gardening. That's not the sense. It's social justice and ecological justice go hand in hand. If we don't have the one, we don't have the other. And this always demands radical democracy with commitment, with ethical behavior with life. I would say then that I invite you all who are here present to assume a position. Years will go by, this is my case. Like grandfathers and grandmothers, what will you tell your grandchildren if they ask you if you were on the side of life or death, if you were path of the accomplices and contract killers of the extractivism or of those who are defending life? Thank you very much.
Muchísimas gracias.
Thank you, Judge Alberto Costa. And next we'll hear the oral verdict of the Oral. Okay, good afternoon, everyone. With the permission of our president and our colleagues from this space, I would like to refer to the Peruvian case that, as you heard this morning, it alludes to Lot 64, and this is not a new case for this tribunal. This was already heard in New York and in Belém, and now we come back to us, because even though these history and previous decisions exist, there is a threat still in these indigenous territories by oil activities, mining activities. Lot 64 has been included among the projects that are of interest, national interest, and Petroperu has maintained the contract and is moving forward with the actions related to environmental studies and seeks an operations partner. All of this is happening in ancestral territories of Ashuar, Wampi, and Chapra people. After hearing the representatives, I think we need to look at this case beyond the existence of an oil block. I believe that this is what they stated. We heard them, and they told us that their territory, is culture, is fishing, is a pharmacy, is life, is food. We also heard the impacts to plants, to waters. We heard also about the division this type of project has caused in communities, the persecution and the threats to those who defend the territory. And we also heard something that impacts this case. After more than 9 years of resistance, the people continue to say that they don't want the reactivation of oil activities. And this poses a deep question. What's the meaning of for justice? What does it mean for justice that people need to defend this for decades, something that for them is the creation of existence itself? And there's another element that I would like to highlight. This lot 64 that they are referring to doesn't end in the place where oil is being extracted. The eventual production of this field links us to supply chains, transportation chains that connect the Amazon region with the coast, with the North Peruvian pipeline and the refinery. And this forces us to look at extractive projects at a different scale, not as a block in the grid that we find in the maps. For them, they can be a block or well or pipeline or refinery, but as a project that is differentiated. But for nature and for peoples, there is a connection. There is this connection of life that is put at risk because a river doesn't know or is not limited by a concession. Because fish are not bound or limited by administrative boundaries, and the cumulative impacts cannot be understood just by looking at each infrastructure in an isolated manner. And this also appeared in many of the cases that were presented to us here today. If you remember, colleagues from Brazil told us that for the state there are spots and points and blocks that are separate, but for the people, this is a territory, the reef barrier, the Atlantic coast that is interacting with the Amazon. In Venezuela, we heard how oil extraction turns these areas into sacrifice areas. And in Bolivia, they spoke about the contradiction between conservation and oil activities. And in Colombia, we heard once again the powerful voice of the UAS that has illuminated us for many years, that have had to defend question projects. So that's why I think that each one of the contributions that can be made by this tribunal have to do with the reinstituting a comprehensive view where extractivism and the economic system fragments reality. To understand that we inhabit a model that destroys other worlds that have no possibility of coexisting together. They stated this clearly. The UA stated that extracting oil is extracting blood, and that means the death of the planet. but I would like to say something about those who make it possible to defend these territories. We heard that in Peru, we heard about the persecution and threats, as we also heard from other colleagues that presented their situation. There is criminalization, there's persecution of fishermen, of leaders, of men and women that denounce these impacts. So I would like also to pose another question that I think is important. What happens to nature when those who defend it are persecuted, threatened, or silenced? Because to recognize the rights of nature cannot simply signify recognizing the right of a river, of a forest, but actually we also need to guarantee the conditions so that those who inhabit these territories may defend them, may organize themselves, and also may be able to decide about their links and ties to the territory. Regarding the decision of this tribunal, because I'm being signaled that I'm running out of time, this tribunal believes that we need to reintegrate our statements about Lot 64. And therefore, this sentence first reiterates the recognition of the rights of Mother Earth and the rights of the Shuar, Wampi, and Shapra people over their ancestral territories. And second of all, we would like to request the suspension of the actions aimed at reactivating oil activities in Lot 64 as long as they don't fully recognize the rights of affected peoples and the rights of nature, which no doubt will be impossible for this type of activity. Third of all, we call upon the Peruvian state to review and cease to implement these laws, particularly Supreme Decree 024 of 2025 EM, according to the national and international obligations enforceable. Fourth, we call upon any decision over the territory to fully respect the rights of prior, free, and informed consultation and consent of the affected peoples. Fifth, we request the restoration of the ecosystems and territories that have been affected as a consequence of oil activities in the past. Sixth, we recognize the importance of the self-government forms and self-understanding of the peoples for the defense of their territories, and we call upon the state to guarantee the conditions so that those who exercise this defense may do it without any threats and persecution, without criminalization. And seven, we agree to submit this decision to the Inter-American Human Rights Commission and other international bodies that are relevant as a contribution by this tribunal to the defense of the rights of peoples and of nature. And we request to establish follow-up mechanisms on the compliance of these recommendations. I ask for an additional minute to say that we know that this sentence of an ethic tribunal doesn't have the coercive force of a state judgment, but that doesn't mean that this lacks any force. We may have the strength and force of naming what's happening, of recalling, of recognizing the voices that have been silenced and opening up paths to new forms of justice. That's why I would like for our decision not to only condemn what has happened, but also to be a message for the Ashoar, Wampis, and Shapra people. Your resistance matters. Your recognition matters. The defense of your territory is legitimate, and the future that you're defending deserves to be recognized as possible. Because perhaps justice is not only about repairing the damage after it occurs, but it also has to do with guaranteeing that people can actually continue to be people, that a territory is a life territory, and that those who inhabit it may continue to exist. This is perhaps one of the ways that this tribunal can help you unite. Thank you.
Muchísimas gracias, Tatiana.
Thank you so much, Tatiana. And next we'll hear the judge, also from Colombia, Yuvelis Morales. Here we have heard for close to 8 hours, 6 different cases that not only speak of the rawness of those who defend life and defend nature, the rights of Mother Earth as they try to survive in a world that calls for them to be exploited and to exploit others. We have seen the degradation of nature today, but also a world that continues to condemn those who make the world possible, as if this were what life is all about, to continue to exploit wells as if this was the meaning of the territory. We have seen how they have narrated the fragmentation of life itself when we were told that the well has a name and not an interconnectivity. We have also heard how the cruelty in the exploitation of fossil fuels makes life degrade itself. And in that life, we find colleagues, peoples, nations, fishermen, Afro-descendants, and identity. We have seen how cultural identity in itself, ancestral and ethnic identity, is lost in the discussion of fossil energy and the need for this world to continue to extract it without any consideration for Mother Earth. We have seen the irresponsibility of the states, and also their complicity with the companies regarding the transgression of the rights of nature, pollution, and degradation. We have seen how, in spite of having judgments and international rulings, they still condemned biodiverse territories to be forgotten and to be polluted. We have also seen and heard during this tribunal, during 8 hours, very cruel stories that also show the resilience, the love and strength that they have when defending life. In this situation, our biggest question is that in this region of life, they continue to kill those who defend life, that the voices are not only disappearing, but they are hidden later within the noise of companies and their irresistible exploitation of Mother Earth. In this sense, this tribunal has the responsibility not only to speak up and hear, but also of condemning all of these actions, extractivist actions of fossil fuels that continue to condemn our colleagues and men and women, the people from the territory, peasants, fishermen, people, nationalities. Today we have heard that one of our main enemies is indifference and the need not to make them uncomfortable or not to make ourselves uncomfortable given the destruction and dehumanization and denaturalization of people and their territories. The discourse and actions on the rights of nature that makes them uncomfortable because it shows the cruelty that companies still have and states as well, the insatiable need of exploiting, the dispossession, the abandonment, displacement, and assassination. We have seen how this notion of development continues to affect human rights, but also the rights of Mother Earth. In this sense, the tribunal is committed to follow up on the judgment of the Inter-American Human Rights Court and to demand from the Colombian state the full compliance of this judgment. This tribunal calls upon the Colombian state to protect the Uwa people, their ancestral tradition and culture and spirituality. In this sense, we want to protect their rights and also the right to a decent life. This tribunal calls upon the state to protect ancestral and spiritual and cultural memory of the Uwa people and all of the peoples. This tribunal calls to respect self-determination of peoples and their territories, their self-government and self-management. And this tribunal also calls upon all of us to think about other possible worlds, including ourselves within nature, not to think of it as a foreign being that disappears, but including ourselves so that any fragmentation to Mother Earth may also hurt us. This tribunal started with a question that was asking people why were they ideal to come as witnesses and appear to this tribunal, and people said because they were ideal because they were children of Mother Earth. This tribunal shows us the power of people, of territories, of rivers, of snakes, of the spirits that exist, and this tribunal is committed so that the rights of Mother Earth and nature be complied with and that our children be maintained. Thank you.
Muchísimas gracias.
Thank you so much, Yubelis. Next, we have our judge, Gregor Milovayo.
De pequena way mahare kasha katima ganwa memoria nuino hermanos y hermanas.
Brothers and sisters, I would like to embrace you now. The sun is in the afternoon, about to reach a sunset, and I now have the responsibility of giving an answer from this International Nature Tribunal to my brothers from Venezuela. But I wanted to reflect on something, because for each question that was asked by this International Tribunal for the Rights of Nature, there was a response, a reply. There was a hope, but there was pain as well. There was a loss present, sitting here. I felt in my own body, in my own skin, everything that we have lived as indigenous peoples. When defending a way of life that has no borders or barriers between nature and the worldview of we have as indigenous peoples. There's no boundary, there's no frontier that tells me that I'm a tree or I'm a human being, or that I'm water and I am a human being, or to say that, okay, I'm part of fire and of nature and I'm a human being. There's no frontier. This is not taught in any school. This is not taught in any university. This is not taught by scientists. The most advanced scientists do not teach this, that have created so much technology. And this is what we are demanding today. This is what I felt in the spirit and heart of each answer to every question, especially by our brothers from Colombia, Ecuador, Peru, with that wisdom and firmness that they are not defending their own life, they are defending millions of lives. Of lives that have no right to speak here, but they are actually happy living in the jungle. There are different ways to express themselves in chants, in roars, and here we are, those who can speak here. So, in that sense, I would like to embrace all of you and give you my solidarity, indigenous brothers and sisters. The Venezuelan case is much harder because the title is very difficult. Sacrifice zones or areas in the Paraguaná Peninsula in the Falcón State. In this regard, we have reached a point where humans are able or capable of self-destructing themselves, of polluting the water they drink, of destroying what they find in water and earth. Fishermen therefore, because of this oil activity, they have taken their way of life and have filled out populations, filled the populations with illnesses and with policies that are not taught by our peoples. They come from the state. And in this sense, this tribunal condemns the Venezuelan state for ignoring the rights of peoples, of fishermen, for ignoring the rights of nature, for ignoring life. And we call upon them that if there is any possibility, they need to repair what they have caused. What they have caused in people and nature. If there is that possibility, then they need to create the spaces so that there may be reparation. For restoration. And if possible, recreate life once again in the peninsula. This tribunal is in solidarity and condemns and requests the Venezuelan state do take these sentence and judgment into account, and we are committed to continue so that this may reach where it must reach and to support our fishermen, all of the things that they have suffered over 100 years of oil exploitation. I embrace you, brothers and sisters, and this tribunal is with you.
Muchísimas gracias a Gregorio.
Thank you, Gregorio Milavalle. Next, we have Patricia Walinga. We have spent the whole day and we have heard 6 cases of 6 different countries, and in each one of them, in each country, we have also witnessed as a tribunal the violations that exist to the rights of nature, that they are violating the right to life as well. And I'm going to recall what I saw in each one of the countries. We start with Ecuador. Ecuador denounced the attempt by the Ecuadorian state for many years now of opening up new wells and oil frontiers and the criminalization to defenders. And Peru, it is admirable the years of resistance that they have carried in indigenous peoples in Peru with oil blocks that have gone through many victories, but they lack compliance. Colombia, we were inspired by the vision of the Uwa people, the blue planet, as they know Mother Earth for. And the blood of Mother Earth, which is oil, whose extraction and exploitation, it's the extermination of humanity. Bolivia is the country I'm going to discuss because it's so contradictory, because the government itself had to declare a national biodiverse park, and at the same time to grant oil concessions there. Venezuela just spoke, the co-president, Gregorio, spoke about it, the sacrifice zone or area, the extermination of nature, and the impact this implies. And Brazil is the where we find the mouth of the Amazonas River and the impact that this case has in with fishermen and indigenous peoples. We have heard the testimonies of all of them claiming justice. For justice, and as a woman of the Sarayaku people, I have seen that they have also gone through all of these cases with the deep vision that we have as indigenous people, the conservation vision, the respect of nature, because well before law stated that there are rights of nature, for indigenous peoples, nature always had them. Nature always had inherent rights because it's part of life itself. And that's why peoples like mine, the Sarayaku, proposes the vision of the living jungle, the respect for it, and that everything may be declared as a living being, a subject of rights. And this same proposal has been made by Brazil as a country for the Amazon region and its integrity to be declared the subject of rights, not only rivers or a specific mountain or lake, but everything that it includes. We have reached the moment where we need to make powerful decisions, not weak decisions. As a tribunal, we need to condemn the states that have violated these rights and contradict themselves. I'm going to point out that in Bolivia, which is the country that declared the rights of Mother Earth with the Charter of Mother Earth, that didn't comply with this. And for this reason, we have a request to be condemned. And not to continue with the Astillero 1 and Yurumas X2, Idombo, and also Tres projects, given the deep contradiction of this state policy that first declares a protected area and later grants an oil concession. It is impressive to see the incapacity of governments and states to comply with their own decisions, their own constitutional decisions, their own decisions made. In Ecuador, we have rights of nature violations. Bolivia violates the rights of Mother Earth. That's why the tribunal needs to condemn these actions. This has been the request from all witnesses that today have appeared to present their cases. Our commitment as a tribunal is to make visible and accompany them as well, because since we are an ethical tribunal, we are also defenders. We are also from this blue planet. Thank you.
Next, we're going to hear from Alfredo Wagner Brego de Almeida from Brazil, our judge. Go ahead, Alfredo.
Buenas tardes.
Good afternoon. I'll just have some very brief remarks. It's going to facilitate the understanding of this appreciation. I would like to say that first of all, because I'm an anthropologist, I'm going to do my intervention or participation is going to be based on the anthropology of the law, which in Brazil is understood as a comparative research. Was comparative research about the definition of legal rules for social conflicts and the modes in which these conflicts are resolved. So law, anthropology of law, has as a starting point their legal procedures and the laws that don't coincide with legal codes written with formal justice tribunals with a specialized profession like lawyers, anthropologists, legislators, policemen, or military authority. And really, what happens today is that they are complex theories, nascent theories, and there is still information that classifies and defines the nature like a subject of right, not a theoretical in a theoretical within a theoretical framework that is being consolidated. This new classification is adaptable. It was here in Ecuador in the first decades of this century, on 2008, I think. And there are different areas of knowledge that come directly from a point of view that is more complex, focalizing relationships of power that get to real organizations so that science and the right can choose as an object of reflection and a comparative perspective nature as a subject of rights. This is not natural. This choice is not natural. It's not spontaneous. It is built, it is deliberate, and it is a work that is very hard so that we can assemble all of this. And the occurrence of this project, the result of this process is that this national law has included the rights of law with the indigenous peoples of the life territories versus, like we see in the table, the Brazilian state. The exploitation of oil in the forest Amazonas, in Marajó, in regions of Amapac, and from the perspective of public ministry, go all the way to Rio Grande do Norte, incorporating the greatest mangrove in the world and the coral reefs of the northern coast, and having to the east the region of the low Amazon, proposed in complete legal actions from this perspective for several months. In April and last May, the public federal ministry versus La Unión and versus the National Agency of Oil. So these are the instances that have put the Brazilian state versus the peoples or indigenous organizations in the regions of north of Pará. So these are two difficult contradictions that are at play and that are having us debate here. It's a very complicated manner. It's not simple. So in this sense, there's a duality. There's a conflict, social conflict and tension. In 2025, since the announcement of 47 exploratory blocks of oil and gas that were marked for 17th of June of 2025. These social movements versus the union. This is how the legal process went. So there are two forms of contradictions that face and have a single point of convergence. In this sense, it's important to not mix union with state, state with government. And when we talk about these things, we mix all the categories that have these sense and different implications. There's an internal public dispute known within the apparatus of the state that oppose the federal public ministry and the union and the National Agency of Oil and Natural Gas. And PF went with a judicial action on 12th May 2025 and required the immediate suspension of all the blocks of oil and gas until they had fulfilled a series of measures foreseen in the legislation, even including public debate through referendum. So this is a central point where we can think about how to work politically. With this, the public federal ministry emphasized that this happened with that the occurrence of exploitation without previous consultation is a grave violation of international commitments with the Agreement of Paris, Agreement 169 of ILO. My apologies, but he's mixing Spanish with Portuguese. And a single federal tribunal to prohibit the exploration of oil in the foss of Amazonas for Petrobras. And so we try to bring down these concessions in 20th of October. And so there cannot be any licensing within Block 59 that has 500 kilometers from the coast of Foz. Sorry, that from the 175 kilometers from the continent, without some studies of climate change, of sediment, and of indigenous components. Like we say in Portuguese, all action must have the components called indigenous, Cimarron, and of other peoples. So there is, if there is some kind of a spill of oil, you put into danger unique ecosystems, and once these ecosystems are damaged, so if there's a spill, there's an infringement of the international commitments, and everything should be stopped immediately. 3 months later, we had in 14th of January of 2026, we had the spill in Foz de Amazonas at a depth of 2,700 meters. Now with a map of our Italian colleague, we're able to see 1,500 kilometers. So we're going to have a great impact because of the length and depth. We'll soon see what is the area that is influenced. The indigenous peoples of Amapá in the northern Pará and the municipality of Caciques in Oiapoque have denounced the lack of respect, the disrespect to previous informed and free consultation that didn't occur. In 2 of March of this month, Public Federal Ministry suspended the license. So there is a strong attack within and combat between the official branches of the state. It's not easy to know where we're going to end up with this. Only social movements began demanding the suspension of oil concessions and began to defend free territory that is free of fossil fuels. In this sense, the infringements have been through. I'm not going to repeat all of it, but I am giving the material in writing. I am favorable to the condemnation of the apparatus of the state, like the National Oil Agency, Petrobras, and especially the coalitions of oil interests that are the big companies like Chevron, Total, the big companies that seek to break the area, to destroy the area, making every bidding process be just for public investments. Thank you very much.
Muchísimas gracias, Alfredo. Y antes de poder...
Thank you very much, Alfredo. And before hearing the final verdict given by our co-president, we're going to hear from Francisco. Thank you very much. I think that after the words that we have heard from our colleagues, judges, which I thank very much for their commitment, there's not much more to say. Allow me, however, to make some final considerations. First, we've never heard before ulterior confirmation of what this tribunal in its trajectory has denounced and confirmed. So that the dominant model of extractivist capitalism that we've already judged in this tribunal is an ecocidal model that destroys life locally, regionally, and globally. Because when we talk about oil well, like Tatiana mentioned, that we talk about a set of infrastructures that are going to impact in the quality and destruction that began in the well and end up in the atmosphere. And this is also puts us in a challenge of identifying what is the chain of co-responsibility, co-responsibilities in these crimes against the environment. And it is also an ethnocidal model when we've talked about the Maya train, because this is a model that is going to undermine the basis of the identity of the peoples, the culture, the cosmology. It completely changes their way of life and living, and it is a model that prospers in forms of patriarchy. We cannot forget that women with their bodies and territories are in the first line of defense. They suffer, they take care of life, but they suffer doubly because of the cultural and environmental and spiritual impact of the extractivist model. Extractivist model that prospers with coloniality and racism. Today, seeing the map of the possible environmental impact of the spills of the Foz do Amazonas, it caught my eye that within the environmental impact, they say this is going to be suffered in the islands of the Caribbean, which incidentally have Afro descendants, descendants of slaves. So externalizing the impact of the extraction in populations that are Afro descendants is an evident way of environmental racism, just as with the Quilomboas and indigenous populations. And this is a point that we have to take into account. This is a way that transforms life into a commodity, as it was said by Olivia in her moving testimony. When life does not have a price. This is a system that configured in sacrifice of life and ecosystems that are sacrificable, but they're ignored, where they're refuse to recognize rights. My co-national Giorgio Gambay talks about lives, human and otherwise, whose dignity and rights are attacked. Our task is to restitute these rights and defend these rights. The extractivist model generates crimes of system where impunity for the destruction of the basis is accompanied by indiscriminate attack, repression of any kind of defense. It's a system that devours itself. There's a term in Greek, ecophagia, the destruction of our home. We are destroying our home and our nature. The tribunal then commits itself to guarantee the implementation of this judgment that we're going to give to governments, to companies, to the Inter-American Commission of Human Rights, and to the Secretariat of the Conference of Cooperation of the Amazon States that next year is going to have its annual meeting here in Ecuador. I want to thank, in closing, because I have a little bit less of 3 minutes. I want to thank all of you, witnesses and experts, but mainly men and women who left their territories, that went into a long trip to arrive here. They left their homes, their families, their lands, and who are putting their face and their body to protect the Mother Earth. They're doing of this fight for life and dignity. You face risk, violence, threats, and their commitment is not only a signal of hope, it's fundamentally a signal that makes us responsible more as a tribunal to offer a space of effective and concrete fight for reparation, justice, freedom. The statistics demonstrate that in all environmental conflicts, those who win, those who are able to stop projects of extraction are indigenous peoples. And this is even more for us a message of more commitment and responsibility. And I want to finish with words of a decolonial philosopher from Cameroon, who created the term necropolitics, the politics of death, and he talks about how to restructure radically the relationship between humans and non-humans. When he says the reparations imply renouncing exclusive forms of appropriation, recognizing the existence of what is incalculable and what is inexplorable, and which in consequence cannot have possession, occupation exclusively of the land. The land belongs only to itself, and its reserve of life cannot be object of appropriation. So I think this summarizes quite well the cultural and philosophical background of our work. Thank you very much. Now I cede the floor to our co-president, Gregorio, to read the preliminary ruling.
Bien. Que se vuelva a oír ese aplauso.
Let's hear the applause again for all of you who have accompanied us with dignity and courage. And you give us hope to continue fighting. With the permission of the sacred spirits of the Amazon jungle, with the permission of the grandparents who are present here, who have come from far away, of the family of children, with your permission, that are coming with the hope to receive a message that you may take to your home and your country, so that we can live somewhere else, somehow differently. This International Tribunal of the Amazon of Nature, in its third edition, I would like to ask a round of applause to this honorable tribunal at this moment.
Y agradecer.
And thank that the spirit of the jungle can speak us today through those who are wearing feathers, because this tribunal today is not only used its five senses, it also used its heart, it also used the world vision. The world vision does not appear in regular tribunals, and heart doesn't appear either. And the thirst of justice is never satisfied in ordinary tribunals. So, brothers and sisters, today we saw in your eyes, in your words, in your denunciations, in your claims, we saw a thirst for clean water. We saw a thirst for life, of full life. We saw a thirst for justice and dignity for our people, for nature, for water, for air.
Eso sentimos en este Tribunal de la Nación.
That's what we feel in this Tribunal of Nature.
Estuvimos un tiempo necesario.
We spent necessary time to understand this pain, this joy, this hope that you expressed today, and this love for life. And this tribunal reaches the following conclusions after these deliberations. This will be made public in the next few hours. This tribunal declares and makes a commitment, a clear commitment, without fear, that extractive activities have catastrophic effects on Mother Earth, because they are in scale and impact. They produce a profound risk to life and to existence of human beings and of nature. This tribunal identifies with this struggle and denounces the loss of territory, of life, and the breaking of relationships, of spiritual relationships, community relationships, and family relationships which has been mentioned today. This tribunal condemns the persecution, criminalization, murder of defenders of land, the rights of nature and life. This tribunal ratifies today this profound relationship that regular justice does not understand. This relationship between peoples and nature with the land, and that today is being fractured by extractive activities. We also condemn the general subordination of rights acquired and conquered by people to the economic interest of extractive companies, even the rights of protection of land. They continue to sell and to assign territory because of the interests of power and money. We also denounce the systematic violation of previous informed and free consent and the right of peoples to say no to extractivism and yes to life. We recognize the infringement of the rights of Mother Earth and ancestral communities in all territories of the brothers and sisters that have spoken today. We declare the Amazon today and forever as a subject of rights and as an area of total exclusion of fossil fuels. We demand that the referendums be obeyed in Ecuador regarding Yasuni, the relationships with extractive industries, and that the demands of people for their territory to continue to be alive be respected. We demand that the Amazon be declared as an area of exclusion of fossil fuels. This tribunal recognizes that the extractive model constitutes a crime because even with the evidence, scientific evidence, they still insist and propose to broaden the oil border, aware that death, destruction, damage, and disappearance of life are present with these actions. This tribunal recognizes the force and the vital need of resistance and hope so that the victories that we've heard about today and the pain we've heard about today, the hope we've heard today, can be examples for a world that is different and that has to be possible.
Los jueces y juezas establecen.
The judges establish and ratify that the cases heard today constitute profound infringements of the Universal Declaration of the Rights of Mother Earth set out in the summit of Cochabamba, which is the jurisprudence of this International Tribunal of Rights of Nature. Also the Declaration of the Rights of Indigenous Peoples, also the Universal Declaration of Human Rights have also been infringed. Finally, this tribunal supports the resistance the legitimate decisions of the peoples that demonstrate with their actions that it is possible to live differently. Another world is possible. Brothers and sisters, we thank you for being here with us. This is an instrument. I have an instrument in my hands of Roman law that has been many times been used to punish, to ignore, to criminalize on behalf of extractive companies, on behalf of the power of the states. But today, this instrument is going to be used to declare that there is hope, that you are right, that you who have been here denouncing have the power to change this planet, to change the mentalities, to change the power to tell the world that we need water, we need territory, we need land. The nature has heart, spirit, life, speech, and we as peoples will defend it. We have said in this tribunal.
Muchísimas gracias.
Thank you so much, Maria, Francesco, Patti. Thanks to my team, Garn, the technical team, those who prepare the food, the interpreters, the volunteers, the House of Culture, Nature for making this possible, the witness, judges and prosecutors. Thanks everyone. And I invite you to stay because almost immediately we start with the Ecuador Festival with the movie from Roberto Bolinga, Let's Be the Voice of Nature. Thanks everyone. Let's have an official picture of the judges before they leave.